Good morning, all. This hearing is in the matter of CFI 079-2023 and is being held by way of video conferencing before His Excellency Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimants are represented by White and Case. Lead counsel is Mr. Tom Montague-Smith, KC. The defendants are represented by Habibul Mullah. Lead counsel is Mr. Stephen Doherty. Thank you, Your Honour.
Thank you. Well, good morning. I've received notice of the timetable that you've agreed to. So bearing that in mind, I propose that we proceed as follows. At about 11:30, or as convenient to Mr. Montague-Smith, we'll take a break for about 15 minutes. We'll then resume at 11:45 and continue for an hour and a half then, which takes us through, I think, to 1:15, at which time we'll take a 45-minute break for lunch, if that's suitable to everybody. And we'll then, I'm not sure if I just got those times right.
You have.
I have. All right, 45
Yes.
minutes, and then resume for Mr. Doherty.
Very good.
All right, Mr. Montague-Smith.
Thank you very much. And firstly, thank you for fitting us in. I know it's been a difficult process finding 2 days in everyone's diaries. So we do appreciate your honour getting on with it. We both put quite a lot in writing.
Yes.
You've got almost 200 pages from me, which is unusual, certainly for me. But you have 200 pages from my learned friend as well. And so what I'm going to try to do is, while retaining the shape of the submissions, not deal with absolutely everything. And I hope you've had an opportunity to read them. There's a lot to digest. It may be that. Very good. Thank you. At the outset, I should say this. There are a number of respects in which we say my learned friend's submissions are quite remarkable. They seek to withdraw issues which have been agreed. They seek to advance allegations for which they were refused permission to amend. They make opportunistic procedural complaints, for example, about disputing the authenticity of documents. I have to deal with all of this. They make very serious criticisms of me and my junior for suggesting that Mr. Shehata was lying and had fabricated documents. But at the same time, they close on a case where they accuse all of my witnesses of lying in circumstances where they never put that to a single one of them. And they close on a case which in multiple respects was not put to the witnesses. And I'll come on to that. That's largely important in the context of, firstly, how MCC, the software, was developed, but also in relation to the counterclaim. And we say, and you've seen it, I suspect, in our submissions, that they completely failed to put their case at all on the crucial subjective elements of their counterclaim. And it was pointed out in the course of cross-examination that failure was happening. And my learned friend's response was, "I'll move on. I understand the point, and I'll move on." But that complaint cuts across the entire counterclaim. It's quite remarkable. And importantly, and I'll have to try and pick as much of this up as I can, they make assertions about a range of matters which are quite wrong. Just simply they're wrong about things that happened in the hearing. They're wrong about things that happened in these proceedings. And it's surprising, to say the least. And again, I'll have to pick some of that up. We had understood that the reason for having such lengthy closings was that we would be incorporating into our submissions the primary material, in the sense that we would actually extract cross-examination transcript references and put them in so you could see them and you wouldn't have to click through. And what you have, I'm afraid, in my learned friend's submissions is not just none of that, but actually unreferenced assertion, which is disputed. And so assertions are made, which we say, well, where is that coming from? And we are left to trawl through the transcripts, try to find what, it's said, for example, that the second claimant accepted that the ledgers that were produced to explain the missing payments, the payments that had been paid into Mr. Shehata's bank account, it said he accepted that that was all reconciled in the ledgers. And when you actually go to the transcript, what is said, when you find it, because there's no reference to it, but when you find it, what is said is nothing to do, or is nowhere near that rather optimistic interpretation of events. And again, I'll have to take you through that in a bit of detail. But what I think the overarching submission that we make in relation to my learned friend's submissions is you cannot, unfortunately, simply take the assertions at face value. You will have to check, and we've done as much of that checking as we can, and I've now got 2 hours and 50 minutes to try and come back to finish that job, but it's not going to be possible to pick up everything because it is quite remarkable. The first issue, obviously, between us is the ownership of MCC immediately before the assignment agreement, and that's where this all began, really. My learned friend's first response to this is a procedural one, or there's essentially 3 procedural responses that he provides. And the first one is a pleading point. He says it's inadequately pleaded, the ownership. Now, he accepts that it is pleaded, as he must, because it appears in the amended particulars of claim, and we have that. We've got an EPE again today, so you should have in your screen in front of you the documents that'll be brought up. If the EP could please bring up B tab 3, page 3. And if it's helpful, Your Honour is able to pop out. There should be a pop out button. So you can both see me and that, depending on how large your screen real estate is in front of you. I thought we had an EP.
I can see you and the document at the moment. Yes.
So if we scroll down to paragraph 13, please.
This is the particulars of claim, is it?
This is the particulars of claim. You can see what's been amended. So paragraph 13, at all material times prior to 19th December 2021, the second defendant owned the intellectual property rights and certain software known as Media Cloud Care. If we can scroll down and see the rest of the paragraph, please. The MCC software. That pleading's been out there since June 2024. And here we are 18 months later, and it said we don't have enough information. The answer, if you don't have enough information, is to make a request for information under Part 19 of the rules. They don't do that. Instead, what they do is they agree a list of issues, and the list of issues agrees, as issue 2, who was and or is the owner and or holder of the MCC rights. Now, if your Honour has the, I don't know whether you have the closing submission separately in a printed form or something.
I do.
Grateful.
Yes.
So my learned friend's closing, if we can go to paragraph 90 of that, please. That's on page 35.
Bear with me. Page 95, did you say?
So it's page 35,
35.
and it's paragraph 90.
Yes.
But my learned friend there says, well, there's a difference. There's a difference between saying that Health Insights Dubai owned MCC as a result of some sort of assignment or sale of rights. It's quite another thing to say that it owned MCC as a result of how MCC was developed. And of course, those are 2 different ways in which Health Insights Dubai could have come to own the software. And you have to recall that to some extent my clients are working in the dark, because on our case, we say Mr. Shehata ransacked the company and left nothing behind. And so, at the time that we were pleading this, and we weren't in control, the claimants were not in control of the company, but they still, even after they took control, have no access to the contemporaneous documents of the company because Mr. Shehata removed them all. That's the case that was put. But it's one thing. My learner friend says, "Oh, well, there's different ways that conclusion could come about, that a company can come to own software." But that doesn't mean that the issue of whether my client owned that software is not in issue in these proceedings. It's clearly and squarely in issue. And when one thinks, it's pretty remarkable, my own friend puts this point, because it's his own client's case, it's Mr. Shehata's case, that he owns MCC. He says he personally developed it all by himself. Now, precisely what he now says he did to develop MCC is entirely unclear, and I'll come on to that. But there's clearly and squarely a dispute between the parties. So if we go to B tab 4, page 4, please, paragraph 20A, this is the amended defence and counterclaim. B44, please. If we go down to paragraph 20A, thank you. Without prejudice, the matters set out in the paragraphs that follow, the first defendant was at all times the sole owner of the MCC rights and the MCC software. And then if we go over the page, paragraph 22D, please. If you need to scroll, zoom out, EP, then it might help. For the avoidance of doubt, MCC is a cloud-based hospital management software, so a management information system solely authored by the first defendant, who retains all rights in relation to the MCC software. So two things. Firstly, the court was always going to have to look at how the software was developed, because it's my learned friend's own case that as a result of the way in which the software was developed, you can draw conclusions that Mr. Shehata was the owner. But secondly, you've got a raft of complaints about the way it's pleaded by us, but that is how it is pleaded by them in terms of ownership. So it's said, oh, well, we haven't pleaded specific provisions of UAIP law. Well, where is that in my learned friend's defence and counterclaim? Now, to some extent, these complaints are simply a rehash of the complaints that were made at the adjournment application. You will recall that, of course. So, for example, at paragraph 99, if you go over to page 39 of the closing. No, EPE, sorry, I'm referring to the closing, so you can pause. So it's page 39 of the closing, paragraph 99. Thank you. My learned friends complains about new issues raised for the first time in reply statements. You see that in the end of the first line and the beginning of the second. And I remind Your Honour that you've rejected that submission already. If the EP could please bring up bundle F, and I think it's tab 14, page 23. And it's paragraph 132. This is your decision in the adjournment hearing, the reasons that you gave subsequently. There was no evidence of a tactical ambush, and I think you have also said there's no issues, there were no new issues raised in those. Sorry, I don't have the precise reference, but it's in that judgment.
Yes.
So what we've got is, and you'll see this repeatedly, my own friend simply ignoring the decision that Your Honour made, and particularly when we get to the counterclaim, what he does is he just, having been told he's not entitled to introduce certain issues, he just introduces them in his closing. And so we have to go through his closing and strip out and do a filtering process. And we would suggest that that is an entirely unhelpful way to go about preparing a closing. Now, in his closing at paragraph 138 this time, sorry, I should have given you page numbers, but
it's all right, I can get
it's
the
that time of
paragraph
year.
number.
Thank you. It's page 48.
Yes, I have it.
So what he resorts to saying is the defendants will invite the court to find that it simply cannot determine in the claimant's favour the issues of ownership and foreign law on the basis of the pleaded claims, but then goes on to argue the case that you should decide it in his favour. So he resorts to saying that the issue, or if it's on the table, can only be decided in his favour. And of course, that's not the way that litigation works. You don't get to agree an issue is to be decided and then withdraw it, but only if it looks like you're going to lose. As I say, we say it's not surprising that from our side, from the claimant's side, we are light on detail, if I can put it like that, because my clients were not the ones who were directly coding. They were not in charge of the company. And as I say, they didn't have, and they do not have, access to the documents and files from that period because the first defendant was in control. So they've had to piece it together. And relying on what's been produced voluntarily by the defendant, but also on the evidence of the witnesses that they've been able to gather. And really, we would suggest that it's the witnesses that the defendants are complaining about, because before those 4 witnesses came along, they considered that because the claimants were not directly involved in coding and Ms. Hosny was not directly involved at the relevant time MCC was coded, they thought Mr. Shehata would effectively have a free run at telling the court how the software was developed. And so he said, well, it was all me. I did everything. And then when the evidence came in from those 4 witnesses, supported by the documents that were produced, that was when they made the fuss, because that evidence, particularly the documents, simply, we say, demolished Mr. Shehata's account of what happened. And it's really what you're witnessing. It is a sort of response to the fact that those witnesses gave credible and coherent evidence, which was barely challenged in cross-examination, and also the catastrophe of Mr. Shehata's performance in the witness box itself, which I will come on to. So that's the pleading point about ownership. There's a pleading point about applicable law as well. That's in the closing at paragraph 139. There's reference to the case of Abdel Salam, and you will see halfway down what is said on the 4th line. Even in the case of domestic law of the DIFC, it is essential to expressly plead provisions of DIFC statute which are relied upon as founding a claim. And then they say, even if this had been a case governed by the DIFC intellectual property law, C's pleading would have been defective, and refers to the case of Abdel Salam. If you actually look at that case, unfortunately, the cases were only uploaded last night, so I don't have a reference to that, I'm afraid. I apologise. So sorry. Someone sent me a... There we go. I think it's H57. Yes, that's the one. Thank you very much. And if you could find, please, paragraph 53, EPE. Paragraph 53, please. So it's going to be quite a way down. Thank you. Thank you. I've got a wrong reference here. Sorry. Bear with me. I'm so sorry. I've got this is the defendant's authorities were uploaded last night, and I haven't managed to get the references right.
Okay.
Don't think that's the right one.
See, back at 52, there's a reference to RDC 734 requiring all claims forms must state the law which
Yes,
governs the
correct.
dispute.
That's the one. I've got the wrong reference to the paragraph.
Yep.
I'm so sorry. So yes, what is actually said? So the proposition that's being advanced is that you've got to plead all principles, all statutory law that's being relied upon. In fact, what the case says is second sentence. In common law jurisdictions, a party is required to plead the facts which constitute the cause of action and does not have to plead points of law, subject to this exception if a cause of action is statutory alone. However, such as a breach of statutory duty, it would be necessary to plead the statute and its breach in order properly to plead a cause of action. So you are simply faced with a total misreporting of the what is said in that case. It doesn't say what my learned friend says it does. You don't have to plead principles of law. Indeed, my learned friend didn't plead the particular statutory provisions that are relevant. I think my learned friend acknowledges that where we're dealing with non-DIFC law, there's a technical requirement in the rules that says you're supposed to plead out the foreign law, but I think my learned friend acknowledges in his submissions that that requirement is not strictly applied. But where does it take us? Because both parties, at least until last night, agreed the principles which should be applied, and those are the same under UA and Egyptian law. And both parties independently cited them in their openings. Now, overnight, my learned friend put in a large number of cases. So he's put in 63 different cases. And most of those are referred to in his submissions. So they should have been uploaded previously. But buried within them are 3 authorities which are not. No notice was given. We've introduced 2 new authorities to deal with points that my learned friend raised in his closing. And the way that we did it was we provided them to the other side, and in the customary way, we identified the relevant passages of them that we were intending to refer to. Instead, what my own friend has done is he's put in 63 items, and within them, he's included 3 authorities on UAE law. He hasn't told me which bits of them he intends to rely on. He hasn't told me what principle he intends to assert on the basis of them. So I won't find out until he tells me, at which point I will have 30 minutes in response. And presumably it'll be either later today, which is the 19th of December, where I have no access to UA law input, or it'll possibly be on the 23rd of December, when I'll have no opportunity to identify it. Now, the principle that you're supposed to plead foreign law is so that nobody's caught by surprise like this. And so on the one hand, my learned friend complains about a failure to plead foreign law, that is UA law of IP or Egyptian law of IP, doesn't much matter which applies, which everybody knew applied because there's a piece of legislation, and that's the only ones that we rely on. In the same breath, he then produces a bunch of new authority, which he doesn't tell me what he's going to do with it, which hasn't been referred to previously. And so he's very much relying on the letter, but not complying with the spirit, we would suggest. I'll just have to wait and see what, if anything, he says about those things, and then we'll just have to try and deal with it when it comes. The second thing my learned friend says is that I cannot win the argument on ownership because I don't have any expert evidence. And this is an area where we did introduce a certain one case, because we say we don't need expert evidence for a number of different reasons. He said, we say we've produced evidence from the people who actually undertook the work to create MCC. We have evidence of how the software was actually developed. You'll recall the witnesses describing taking M+ and reproducing the workflows in a different language. Now, my learned friend doesn't identify the issue on which the court requires opinion evidence. And that's the issue for expert evidence. Does it involve the expression of an opinion in a way that is inadmissible? My learned friend conflates this, because if you go to his closing at paragraph 129 on page 46, his complaint is, he says, second line down, the 4 additional witnesses' evidence which purport to give evidence on technical matters. Now, giving evidence on technical matters doesn't need to be done on expert evidence. What expert evidence is necessary for is opinion. Opinion on expert evidence on technical matters is generally given by experts, and of course, expert evidence is very often on technical matters, because it's on technical matters that sometimes you need opinions. But in this case, what we're primarily dealing with is the direct evidence of people saying, this is what I did. This is how this software was in fact developed. I sat down at my computer and I coded. That's technical in a sense, but it's not opinion. It's just direct fact evidence. And even opinion evidence is admissible to an extent. So the classic example is where you've got a car crash or something, and somebody says, well, I think the car was traveling at about 60 miles an hour. That's an opinion, but it is admissible because essentially it's shorthand for explaining a complex set of facts which are not easily communicated otherwise. Now, even beyond that, where technical people give factual evidence, their opinions are still admissible. This is where I need to find one of my cases which went in yesterday, and it should be in bundle H, and it's the case called Brendan International, which just takes me, that would be helpful. Yeah, it's at H120, please. If we could please go down to page 19 of that. And down to paragraph 86. So this is a decision of the Court of Appeal in England. The position of witnesses who give both evidence of fact and evidence of opinion in a field in which they have particular expertise was considered in multiplex construction. Mr. Justice Jackson stated, the question then arises as to whether the witness is confined to giving evidence of fact without including his expert opinion on matters. Alternatively, can we scroll down a bit so we can see a bit more, please? Alternatively, can he include statements of professional opinion bearing upon facts within his personal knowledge? This question arises in many fields of litigation, for example, professional negligence actions, where the defendant is a witness of fact, but also wishes to justify his actions by drawing upon his professional experience. This question arises with particular frequency in litigation in the technology and construction court. Most factual witnesses called are possessed of technical knowledge and expertise. In relation to major engineering projects, those factual witnesses are likely to have very considerable expertise, otherwise they would not have been engaged upon such projects impositions of responsibilities. Despite the diligent researches of counsel, there's relatively little authority on the extent to which witnesses who are possessed of special expertise can gloss their factual evidence with expert comment. And then refers to the case of Lusty, where the Court of Appeal held that an architect suing for fees could give opinion evidence as to the value of the work. And another case, Dean and Greenwich, the Court of Appeal dismissed an appeal against the trial judge's finding that an educational psychologist had been negligent. One of the issues in the appeal concerned the admissibility of opinion evidence given by the psychologist. I won't read out the whole thing, but you can see, if you look at this passage and continue down to paragraph 87, it's noted, so over the page, please, on page 21. Paragraph 87, that decision was referred to without any adverse comment in Rogers and Hoyle, and then it's worth reading all of this eventually. But then paragraph 88, on this basis, the judge would not have been justified in thinking, if he did, that Mr. Griffiths' opinion evidence was rendered inadmissible because it was not given in accordance with Part 35. And in the course of that, it said, well, it's common practice in the TCC, Technology and Construction Division, to do it this way. So in other words, what in England is Part 35, the rules relating to, the procedural rules relating to expert evidence are not the beginning and the end of the sorts of expert evidence that can be introduced as a matter of common law. Now, in reality, the only issue which is actually identified as being opinion is identified at paragraph 179 on page 63. And third line down, the complaint is about each of the claimant's witnesses at some stage using words to the effect that it is almost impossible for a software like M+ and MCC to be developed by a single person. And they say, well, he says there's no reliable evidence to support that because they're not independent. And firstly, we say, well, that's hardly opinion evidence because ultimately they have seen what actually went into developing it. So they know that one person could not have done this by themselves because they know what it took to actually do it as a matter of fact. Now, if you call that opinion evidence, that is no more opinion than someone standing by the side of the road saying that that car is traveling at 60 miles an hour. But even if it goes beyond that, it is admissible. It's admissible evidence. So again, this idea that the case just falters because there's no expert evidence, we say, is just flat wrong. Now, the other technical point that's made against me is it said I'm not allowed to challenge the documents which Mr. Shehata had produced. So if one looks at paragraph 114 of the closing, you'll see that at page 42, fabrication of documents. What they say is that the rules require notice. Sorry, I think we've got somebody with their mic on. If I can ask you to turn it off, please. Thank you. They say the rules require a notice of that you challenge the authenticity or don't accept the authenticity of a document, that we haven't filed the notice, so we are deemed to admit the authenticity of those documents. That, with respect, is an opportunistic point. The first point here is that the authenticity of the documents was put in issue in the pleadings. And I'll remind you that the four documents that were in play are these. You'll recall there's the purchase order, which was a document which purported to show that Health Insights Asia had instructed Health Insights to buy to create MCC in about July 20, sorry, I've lost the year. But then there was the partner reseller certificate.
Was it to create MCC or to create some modules? I can't remember.
Well, there's an issue about that, and I'll come on to it. But we would say on its face, it was to create MCC. It's later said it was to create some modules, but there we are. So there's the purchase order, which was for $1 million. But we'll look at the documents. The partner reseller certificate, if you recall that was a document that was issued by Health Insights Asia to Health Insights Dubai, and it said that is how Health Insights Dubai got its right to resell, albeit we say that doesn't make any sense because on its face it doesn't do that, and Mr. Shehata in evidence accepted that there was no other document, there was no actual agreement. So in any event, there's that document, and then there's the licensing agreement, which purported to be issued by Mr. Shehata to Health Insights Asia, which explained the chain of licenses. And again, I'll explain why we say none of these documents make any sense. And then, of course, there's the assignment agreement, which is the central agreement by which we say it appears to cover the whole of MCC, and it looks like they were seeking to sell MCC for a pittance. Now, we accept that the assignment agreement is authentic in the sense that it was created at the time and appears to have been intended to do what it says, which is to sell MCC. But we do not accept that the purchase order, the licensing agreement, or the partner reseller agreements were authentic. And all of those three things are pleaded. So if we could get, please, bundle B, tab 3, page 4 up, paragraph 16. So the claimants do not know whether the purchasing order is a genuine agreement and/or was executed on the date asserted, and put the defendants to proof in respect of those matters. And then in the reply to the defence and counterclaim at B54, paragraph 10, subparagraph 3, you'll see about halfway down, the claimants do not know whether the licensing agreement is a genuine agreement and/or was executed on the date asserted, and put the first defendant to proof in respect of those matters. And then paragraph 10.5, partner reseller certification, same thing again. Now, you will see in my learned friend's submissions the assertion that there is no challenge, no mention, he says, of the partner reseller certification in our pleadings. Well, here it is. That's another inaccuracy in his submissions. So I'll come back to that. Now, the rule is Rule 29115. I don't know whether you've got a copy of the rules.
No, I haven't got them separately, but you can go ahead and tell me what it says.
Thank you. All right. So what it says is, thank you. A party shall be deemed to admit the authenticity of a document produced to him under Part 28 unless he serves notice that he wishes the document to be proved at trial.
Right.
So that's the notice. Now, in England, there is a court form for the notice. And so you have to do it in the court form. In the DIFC, there is no notice. There's no court form notice. And so there is no formal requirement. There's a formal requirement as to when it must be served, but there's no formal requirement as to what shape it must take, what form it must take. And the requirement is simply that then you must serve notice that you wish the document to be proved at trial. Well, we've done that in the pleadings. That is sufficient notice, we say. Now, in England, nobody is terribly worried about this, in the sense that if it is not done, then the defect is waived as long as everybody knows where they stand at the time of trial. And so if I could bring up, please, bundle H, tab 119. I'm going to show you a case called Anthony McGann and Michael Bisping, the well-known MMA fighter, apparently. And If you've got that, please, it's H tab 119. If we could go to page 7, please. Again, I'm not going to read all of this out, but essentially, no, sorry, it's H119, H119, please, page 7. Thank you. So if I invite you to read paragraphs 22 to 26, actually, but if you go down to paragraph 24, please, at the bottom of this page, what it says is there is, of course, no general duty on parties to point out to their opponents the procedural mistakes that their opponents have made. However, where a party intends to take a procedural point, which if correct will mean that the costs are being wasted by the other side, the duty of cooperation under Rule 1.3 requires that party to take the point promptly. On the facts of the present case, the high level of realism and cooperation required of parties to commercial litigation should have involved Mr. McGann's legal team in giving notice at this point if it was to be taken at all, either in correspondence or at one of the many case management hearings which took place at a time well before the significant costs of dealing with these issues had already been incurred. And so essentially he says, paragraph 26, no useful purpose would have been served by requiring Mr. Bisping to serve notice after the start of trial, and then just goes on to say, in those circumstances, I waive the requirement or I waive the breach. So in this case, you've got it in the pleadings. It was made clear in the claimant's evidence that they'd never seen these documents before. I'll give you the references to those, but we don't necessarily need to go there. That's at Bundle C, tab 2, page 10, paragraphs 32 to 33, and C, tab 3, page 10, paragraphs 38 to 39. And the authenticity of the purchase order is indeed one of the issues in the claim. That's an agreed issue. But also, in relation to each of these documents, the defendants were ordered to produce documents relating to the negotiation of the documents. That's Bundle F, tab 6, pages 3 to 4. If
Can I just
you
pause you for a minute?
Yes.
And ask you to elaborate on what you mean by authenticity.
So by authenticity, I mean, firstly, that the document is misdated. In other words, it's being presented as having been created at a particular time.
Yes.
But secondly, that we say that they are not genuinely contracts in the sense that they are presented. So they're not intended to create legal relationships.
What's popularly referred to as being a sham.
Yes. But the importance of those documents is really as an evidential support from my learned friend's case that his client his client owned this software, because he says, well, I can show you that I own the software because I've licensed it to my own company. That's the licensing agreement. Or because my own company has issued a partner reseller certification to Health Insights Dubai. So in a sense, that whether or not it's a sham in the true legal sense isn't really the issue. The real issue is, are these genuinely contemporaneous documents? Because if they are, then obviously it demonstrates that he was saying that he owned it at that time.
Yes.
If they're not, then it's just another way that we say he's backfilling. He's essentially going back over the past and filling in the gaps where things needed to be. In closing at paragraph 161 on page 55, my learned friend says, well, there's no positive assertion that the documents were fabricated, but that we've put their authenticity in issue. We're entitled to make submissions and cross-examine on those questions. We've said you have to prove when they were created. We're entitled to then look at that evidence and make submissions about when they were created, for example. And this is where, if you see 5 lines down, they refer to the pleadings. They say, well, they positively alleged during trial that these documents were fabricating. They didn't assert that in the pleading, where they simply say they didn't know whether the purchase order or assignment agreement are genuine. And then they say there's no mention of the partner reseller certificate at all, referring to the pleadings. But we've just seen that. They say it again at paragraph 253 of these submissions. So again, we see submissions from counsel about things that happened in this case, you are being told, which are just wrong. They're just not true. And we do find that it makes everybody's job a lot harder. So there is, we say, no procedural unfairness in us advancing a case that these three documents were not created when they say they were created. That was squarely put to the witness, and he was given the opportunity to answer that. And so the submission on this front, we say, is unreal. And it's elevated. We're looking at this now, paragraph 162. This further reflects the way the claimants have run this litigation, unscrupulous in their pursuit of tactical advantage. And it is, with respect to my learned friends, two of whom have signed that document, highly disappointing to see that sort of language in their submissions. It's wholly unwarranted. And that is not the only example. They go on to say that we should not have suggested that the documents are fabricated. And they even say that the claimants know full well that there is no basis to plead that they were fabricated. Now, of course, there is a basis. So this is, I'm afraid, just an attempt at a procedural gotcha. And it is somewhat symptomatic of the entire approach. They don't want you to look at the issues. They want to try to say, well, you can't do this and you can't look at that, Judge. You're not allowed to think about whether these are fabricated documents. And we say that's because their case on ownership is entirely unsustainable. I mean, imagine we were stuck with these documents being authentic in the sense that they were genuinely written on the dates that they suggest they are, and they genuinely mean what they say. The court would be left with a series of totally inconsistent documents. We make this point in our written closing. It might be easiest to do it there. If it's page 13 of our submissions, and we go through paragraph 23 and onwards, how the documents are mutually inconsistent. But I'll take you, if we can just bring up, please, E64, page 1. E tab 64, page 1, please. So this is the licensing agreement. And you can see in the first recital, it says, whereas licensor is the sole owner of the intellectual property rights, copyrights and related rights of Medica Cloud Care, which has been developed and so forth. And you will see that it's asserting that at that stage, the MCC has been developed, and that is dated. If we go down to the end, you'll see it's dated November. That's on the second page. But you'll recall that on the third page, you've got an annex, which is dated March 2015, 6th of March 2015. But if we go back to the clauses, you'll see on page 1 of this document, clause 1.1, it purports to confer a non-exclusive, non-transferable license, a right to use, sell, and so forth. And then we compare that to the purchase order on E74, page 1. And this is dated the 5th of July, 2016. And you will see that it is in the first section of it, this is the question you asked, is it just for modules? But in fact, it says, places this purchase order to Health Insights FZ LLC with its address and so on for services as work for hire, underlined in bold, by the way, to emphasize it for the purposes of argument later, to develop the below listed web browser based hospital and clinical information system applications, including their submodules. So it's not just for modules, it's for the system, the application, user interface, front end and server side back end, software tools and framework platforms included in the below list. And then you've got the modules list, and it's a modular system. So of course that's everything. But if you go over the page, you know, it's everything that's essential, because you'll see, for example, the main menu is on there. You'll see multi-tenant administration is on there, and multi-tenant administration is a feature of the whole of the system, because it's that ability to have multiple hospitals link in to a single central system. And you may recall the evidence that whereas before they had to install the software on each individual hospital, now you can just have one. So this purchase order could only make sense if MCC has not been developed, because it's an agreement to develop. That's dated 5th of July 2016. And if we recall how this was introduced, this sort of confirms the point. If we go to the first witness statement of Mr. Shehata, it's at page bundle D, tab 2, page 2. And if we could look at, we scroll down, please. Sorry, can we scroll down so we can get the whole of the second half of the page? Thank you. Yeah, so paragraph 6, you'll recall MCC, this is the second line, second sentence of paragraph 6. This is his first witness statement. MCC is and always has been owned by HI Malaysia. I set up HI Malaysia with the knowledge of both claimants and so forth. And then if you go to the end, the last sentence, it's 3 lines up from the bottom. The claimants also knew that I authored the MCC system, and that HI Dubai's involvement in the same was limited to providing work for hire for which it was paid by HI Malaysia. And if we go down, please, to page 6 of this document, to paragraph 21. You will see that he talks about HI Malaysia, and then 3 lines down, you say, in fact, the claimants would clearly have been aware of this because between 2012 and 2022, HI Dubai derived around 7.7 million in revenues from HI Malaysia for services, including the provision of work for hire services. So this document was introduced to support the case that HI Dubai had developed this software, MCC, for HI Malaysia. So it's directed at showing that HI Malaysia owned MCC. So if you go up to page 5, and the bottom of page 5, please, paragraph 20. He says, 3rd line down, it's always been the position that MCC, which I authored, was owned by HI Malaysia, and it's never been owned by HI Dubai. So this document is completely inconsistent. I'm not talking about the witness statement, I'm talking about the purchase order. It's completely inconsistent with the licensing agreement, which says that it's owned by Mr. Shehata. And there's been no explanation of why not. And it's not just the terms of the document, it's the way in which it was deployed. And then we've got the partner reseller certification. And that was also introduced to show that HI Malaysia owned MCC. We see that from paragraph 22 of this document, please. This is, again, the first witness statement. HI Dubai's relationship with respect to HI Malaysia is that it was a partner reseller. And then specifically on 21st of August 2017, HI Malaysia issued a partner reseller certification, which stated that HI Malaysia owned MCC and granted HI Dubai license to resell and the software to third parties. And then they exhibit the document. The document's at E95, please. That's the partner reseller certification. And you'll see it's dated 21 August, purportedly dated 21 August 2017. And it states that Health Insights FZE, and it refers to the cloud, do you see the second line down, requires cloud collection and so forth, based on Medica Cloud Care hospital and clinical information system software owned and provided by Health Insights Asia as a service model. And then it goes on to say, in the fourth paragraph down, I think it is, you will see this means, so it talks about Health Insights Asia confirms that at the date of this letter, Health Insights Dubai is authorized channel reseller, and that HIA and HI Dubai have entered into an agreement for the purchase and resale of software in the aforementioned territories, and talks about there being some license, and then says at the bottom, the present confirmation is valid for 1 year and to be reviewed on an annual basis. Now, I asked Mr. Shehata about this, and he said, no, there's no other relevant contract between the parties. This is not a contract. This is not a license. This is a confirmation that there is a license, but he says there wasn't any other contract. The references to that, we don't need to go to it in the transcript, are day 8, page 32, lines 13 to 14, and day 8, page 33, lines 14 to page 34, line 4. And in this document, as I say, this document says, no, MCC is owned by HI Malaysia. Now, in their closing, paragraphs 22 to 23, so this is going to be page, sorry, starts on page 5. They say that the partner reseller certificate constituted a license to exploit the economic rights to MCC. That is not what the document says, and not consistent with what the client says. And they come back to this paragraph 106, page 40. And they suggest that this document that I've just shown you shows that HI Asia, Malaysia, had the right to license the software, granted a license to HI Dubai, and gave HI Dubai permission to do that. But the document doesn't support any of that. What the documents show is a non-transferable license agreement between the first defendant and the third defendant, which would not, on its face, permit a further license from the third defendant from HI Malaysia to HI Dubai. The documents do not show that there is an actual license from HI Malaysia to HI Dubai anyway, and Mr. Shehata confirmed that there was no further contract. So this document, the partner reseller certificate and the purchase order, were produced to show, in the first instance, that HI Malaysia owned MCC. But of course, by the time we get to the second witness statement of Mr. Shehata, he's changed his story. Just to show you this, it's bundle D, tab 3, page 16. And he's saying that stage, that's the first time he says, oh, well, actually, I owned MCC. And the licensing agreement was then produced at that stage. There we are. Paragraph 36, that's when he produces the licensing agreement, which he says explains that he owned MCC. So the documents are as inconsistent as the case that was being advanced in those two witness statements. These two, the reseller and the purchase order, don't support the case now being advanced, which is that, in fact, Mr. Shehata owned MCC. So if you have to live with these documents, imagine that. Imagine the unsatisfactory nature of that we'd have to say, well, all of these documents are true. Well, they don't fit together at all. So how is your judgment going to deal with that if you have to start from the premise that these are genuine documents created when they say they were created to do the things they say they intended to do? So we say that the procedural complaints that are raised should be given short shrift. Onto the evidence of how MCC was developed. So now Mr. Shehata claims that he spent years developing what I think everyone accepts as a massive piece of software, and he did it by himself. But he produces virtually no contemporaneous documents in support. Now, the killer evidence on my learned friends submissions is that video that you will recall, which we found, which is at I-16. And this is relied on repeatedly in the defendant's closing submissions. It's repeated over and over again as the critical piece of evidence, but it is thoroughly misrepresented in the submissions. So if we go to the closing paragraph 98, which is on page 36 of that document. Third line down, my learned friends refer to a critical piece of evidence that they say the claimants had no answer for. Well, there are answers to these documents. Mr. Shehata provided them, and I'll come on to that, but there we are. What he describes as a working demo for a web-based system that the first defendant produced in 2014. This is how he's presenting this document. And so he says the source code was written years before the earliest time that we say MCC was developed. And then over the page, just picking out some of the highlights, at subparagraph 2, he says the demo itself shows that it was a version of MCC, which had already been in development. So my learned friend then goes on to give his own evidence about what the screens show. Subparagraph 4, for example, he identifies various elements which he says show, you see at the end of the sentence, i.e. a new electronic medical record. There's no evidence of that. He just says, well, that's what it is. And just noting, just pausing for a moment, if you look at the size of the files there, these files are 1 kilobyte and 9 kilobytes. That's consistent with what we say, which is this is a dummy prototype. It's not just we who say that, but I'll show you that in a moment. Now he says, subparagraph 5, the metadata shows certain things, but of course the actual files were not produced, so we've not been able to inspect it. Well, what they appear to show is that these particular files were not touched since about February, May 2012. Some of them, but quite a lot of them appear to bear dates of February and May 2012, and haven't been changed, haven't been altered since. So the idea that this is some part of the development of MCC is quite difficult to square, but anyway, there we are. And then subparagraph 6, he says, aha, these are CS files, that's C# files. And what that means is that they are in the programming language that MCC was written in. And then he goes on to imply that this is part of MCC. On paragraph 99 over the page, end of the second line, he says the provision of directories and working demo of MCC obviously demonstrate that the first defendant is the author. So in other words, because Mr. Shehata produced it, he obviously wrote it. That's a non sequitur, but there we go. Now, at paragraph 207, later on, he complains about Mr. Al-Shanawi's evidence. Towards the end of that, it's on page 72. And he says, final line of the main paragraph, he sought to explain the evidence away as a prototype. Now, in fact, Mr. Al-Shanawi explained the files are not MCC. They are Silverlight, and that is a different technology. I'll give you the reference to that. It's at day 5, page 168, lines 13 to 20. And one of the points he made is that you can see that the software uses file extensions .xaml. And so XAML is Silverlight, which is a Microsoft presentation format. Anyway, my learned friend says, well, that this document shows that this is all part of MCC, and MCC was therefore in development. The problem with all of that is that it's got nothing to do with what Mr. Shehata said about it in his own evidence. Mr. Shehata accepted that this video was a video of a prototype. He used those words. And he accepted that none of the files in the video made their way into the MCC program. We could bring that up, please. It's day 6, page 168, starting at line 11. So I'm asking the question. I'm afraid I've been working from the transcripts as they were on the system, so my pagination is going to be out, I'm afraid, but there we are. Paragraph, line 8, so I'm showing him I16, this is the file path, sorry, the subfolder pathways we can see as EMR demo, yes? So this is a mock-up you produced, isn't it? Yes, I said this is a mock-up in my witness statement. This is the beginning. I was trying to utilize Silverlight technology from Microsoft to experiment with different technology, how it might be doing that. It was a prototype, actually, as what Mr. Al-Shanawi, your witness, said. So my learned friend criticizes Mr. Al-Shanawi's evidence for describing it as a prototype, but his own witness, his own client, agrees. And if we scroll down in this section, please. Yeah, so I say, line 22, we can keep scrolling, please. So I think you would therefore accept, would you, that none of the files that we see here and none of the files that we might see in this video actually make their way into the MCC program, do they? Keep going, please. No, that was the prototype at the very beginning, and Microsoft has dropped this technology altogether. So I started switching to HTML5 and C#. So when my learned friend says the source code for the system was written years before the earliest time that the claimants say MCC was developed, even his own client accepts that's not true. And this is what we're dealing with. Yeah. It's astonishing. So he'd said in evidence in his witness statement that it was just a mock-up. It's just a dummy. And because he conceded that, we didn't need to point out that, for example, the files that my learned friend cross-examined on and the files that he picks up again as being C# didn't make their way into the MCC code. And you've got a listing of the MCC files. You can actually check this because they produce the full listing. They don't produce the files. But I2 is a 68,000 page document, I'm afraid, which has all the files. And so if you actually just search for the files, you won't find them. And you won't find anything that has a .xaml suffix, because that is associated with Silverlight, which, as Mr. Shehata says, has been discontinued. It's obsolete. It's obsolete, in fact, because of HTML5. Now, paragraph 100, my learned friend says, well, it's all terribly unfair because Mr. Shehata was trying to explain why this document, why this video supports his case. But the complaint is he was interrupted when he tried to do so. And that's a pretty, again, another very... Sorry, I think we've got some people with their microphones on. Anyway, there we are. So he complains at paragraph 100. In his evidence, D1 tried to explain how the video of the working demo showed his authorship of the software, but he was repeatedly interrupted. If you actually go to that, it's day 6, page 166, lines 1 to 18. what was happening was he was being cross-examined about where the video came from, why he hadn't produced these files before. So you'll recall he said he'd lost access to all of his information, and then I was making the point that all of a sudden, a few days before trial, he's able to come up with all of this, and he wasn't answering the question that was being put, which was about disclosure. So I'm criticised for not allowing him to make speeches about things that he wants to make speeches about. And again, it's put as sort of as a criticism of the way that we approached it. And then the second part of this, so you've got this submission that, well, this I-16 demonstrates that MCC was in development because this is MCC. It's not, and everyone agrees that it's just not. The second part of it is, well, because Mr. Shehata produced it, that shows that he developed it. He must have written this. But that's just pure assertion. It's just because he's got access to it doesn't mean he did it. And we just have to take his word from him for it on that as well. It's unsupported by anything else. He didn't let us examine the files. He just produced a video of them. He didn't produce the files. So the reality is that I-16 doesn't take the case any further. Ultimately, there is nothing beyond Mr. Shehata's word for it to support the position that he wrote, authored, owns MCC. It really comes down to whether you believe him in that. Now, we've explained why we say you cannot trust what Mr. Shehata said. Yeah, we've gone through that in quite a bit of detail. We say his evidence was quite extraordinary. My learned friend's opening submission in his closing statement, I think he gets there, paragraph 5. So early on, he says, Mr. Shehata has presented the court with clear, consistent evidence backed by documentary records. Consistency is a factual assertion. It is a matter of fact whether one statement is consistent with another. It's not a question of opinion. As a matter of fact, his evidence has been thoroughly inconsistent. I mean, I've shown you the 2 witness statements where he said, first, the software was owned by HI Malaysia, and second, the software was owned by me. Now, we dealt with this in detail in writing, but I would just remind you of some of the important aspects of it, if I may. And the best place to do it is if we could look, please, at paragraph 54 of our closing. And I'll just run through to make sure that I've made clear what we say about the key points. Now, the first point is that there was a whole range of different dates that he offered for when he said he developed Medica Plus, which is we say the first version of MCC, or the first set of versions, if I can put it like that. That just went backwards and forwards. And then paragraph 56 of our closing, we also say that his explanation of how M Plus was transferred to Health and Sites Dubai was also thoroughly inconsistent. So in particular, you may recall that in oral evidence, I asked him about why he would just give away Medica Plus if he owned it. And so in the course of that, he came up with a whole new explanation for this. He asserted that he had struck a deal with Mr. Sawiris, pursuant to which he would get a larger proportion of the company and in return for handing over the software. The problem then that he faced, and I go through this in paragraph 56, was that he had to explain away all the statements where he'd said in evidence to this court that he'd given it away for free. He'd said that. So first, he suggested, well, when he'd said he got no other benefit from it, he said, well, actually, what I meant was I got no immediate benefit from it. So that's subparagraph 3 on page 25. We've reproduced the the transcript in relation to that. But then he pointed out, this is subparagraph 4, that he'd also said, I did not waive any of my economic rights as an author to M+. And then he had to explain, despite this deal that he'd struck, why didn't he then get a larger proportion of Health and Sites Dubai? And that obviously pushed him back to saying, oh, well, I just gave that up. So he was back to giving away for free what was ultimately a very valuable thing that he said he owned. And so we took this rather circular detour through this newly asserted agreement to explain something which ultimately just couldn't be explained. But you saw there his propensity just to come up with new explanations on the hoof. And then later on, so subparagraph 5, we picked this up in his oral evidence. He suggested that although he had registered Medica Plus in favour of the second defendant, he had retained what he described as a controlling component of Medica Plus. So this came about because I pointed out that, well, he said that the central elements of Medica Plus were rules at work and active medical sheets. Well, he transferred Medica Plus to Health and Sites Dubai. Doesn't that mean he'd given up active medical sheets and rules at work? And seeing where that line was going, he said, oh, no, that wasn't included in the deal. So we had to go through the actual documentary evidence in relation to that, and it doesn't support him. So he's then asserting it for the first time in evidence that he kept some aspect of Medica Plus in his own hands. Again, it just demonstrated his propensity just to make things up, to try to solve problems on the hoof, and then make something else up to try to solve the inconsistencies that flowed from that. Now we say in relation to MCC, his evidence was even worse, and we deal with some of the contradictions that he came up with at paragraph 57. As to the dates when MCC was developed, you may recall this. We set it all out there, but originally he'd said he started developing MCC in 2016 to 2021. And then he said, well, it was 2015 to 2021. And he clearly said, subparagraph 3, in 2012, MCC was not even existent, didn't exist. Compare that to what my learned friend says about mock-up. And then shortly before trial, we get this reference to this mock-up being prepared between 2012 and 2015. He said that's what he said. You see at subparagraph 4, we're just reciting his own evidence. And then in the box, he said, oh, no, that was actually all developed in 2012. And then he says, well, he started to develop MCC itself in 2013. So you've just got this completely inconsistent account. I mean, these aren't small differences. You've got him saying, I started in 2016 to, oh, well, now my learned friend's case is, well, it was all complete in 2016 and it started in 2012 or 2013. This is a significant and we say inexplicable error, unless he's just making it up. And his evidence on when he named the product was also very inconsistent, and the way he dealt with that is also quite revealing. We deal with this on page 27 of our submissions at subparagraph 6, because he had originally said, well, he came up with the name in 2016. You see that in the first line. That's in his 13th witness statement. So just before trial, he was saying that. And then he said, oh, actually, I had the name in my mind since 2015. So I showed him the license agreement, which was dated November 2015. And then he said he came up with the name in August 2015. And I asked him whether he was certain about that. And he said, yes, I am certain. I'm certain that that is when it happened. He said that was when it was brewing in his mind. And that's why he put it in the licensing agreement. This is all on day 8, page 16. But then the problem with that, as we just saw a moment ago, was that the licensing agreement had an annex, and the annex was dated the 6th of March 2015. We can bring it up again, please, while we're talking. It's E64 tab 3. And the problem with that is that the annex has the name in it, Medica Cloud Care. So he's saying, I'm certain I came up with the name in August 2015, and yet there's an annex bearing the name in March 2015. So, sorry, top of the page, please. Thank you. Don't scroll down. Thank you. Well, you can see it. Sorry. Thank you. There. So the name is top right, and it's all through. Anyway, there we are. So as these inconsistencies in his story were shown to him, his evidence changed and changed again. And of course, as we've seen, the story has fundamentally changed over the course of these proceedings. So just going back to our closings at paragraph 58, we make the point that he originally said MCC was owned by HI Malaysia and always has been. And that was supported by the purchase order and the partner reseller certificate. And that became that he licensed the software to HI Malaysia, that he owned it. And at the top of page 28 of our submissions, you can see how he shifts around. So he obviously is confronted with this, and he says, well, owned really meant licensed. So that's what he says at the sort of top half of this. And then, but the problem there is that wouldn't, even if that was credible, even if he was saying, well, when I say owned, I mean licensed, it wouldn't explain always, because he said it's always owned by Health and Sites Malaysia. And so I say, well, that can't, even if you're right, that can't explain why you use the word always. And so then he comes up with another explanation for that. If you see the underlined words, before I licensed it, then it was not owned. The word, if that is what is bothering, the word always is because I owned Health Insights Malaysia totally personally. So whatever I do, I can give its rights to HI Malaysia or to HI Dubai or whatever, the HI en masse. And then he says, second answer, through my ownership of Health Insights Malaysia, yes. So sorry, the question is, do you believe that HI Malaysia has always owned MCC? And he says, through my ownership of HI Malaysia, yes. So essentially, what he's now having to, he's driven to saying, well, yeah, I owned the software, but I do think that HI Malaysia always owned it because I owned HI Malaysia. It's a completely incoherent explanation that he's driven to. He's defending the indefensible, changing his evidence to try to explain away problems, and ending up at somewhere which is just obviously not true. And again, when dealing with the documents, Your Honour may recall the evidence he gave about the creation of the license agreement. So we deal with this at paragraph 60 of our closing on page 28. And you'll recall part of the issues here is that in relation to each of these documents, nothing has been produced in relation to the creation, development, negotiation of any of these documents. There's no independent contemporaneous record for any of them, not one. And so first of all, he said, well, there are no emails or documents relating to the negotiation or the execution or the entry into it. So that's recited there. Then, in his evidence over the page, he said, well, he was sent drafts of the licensing agreement by his lawyer. And you'll see that he changes that evidence halfway through, because he then says, oh, well, actually, I wasn't sent them. We sat together in a restaurant to review them, and he handed over documents on a thumb drive. And we would suggest that what he realized that, as he said, sent, he recognized that that was going to leave a trail, which would expose him to the criticism that he hadn't produced that trail. And so he changed his evidence because he was just retreating back into trying to find the consistent path. He actually did that twice. And there was another period in when I was cross-examining where he did something similar. It's on, I think it's at day 8, page 43. But essentially, he does much the same thing. Well, I've got it at day 8, page 43, lines 17 to 21, but we can look at that. Essentially, he does the same thing. He says sent, and then he says, oh, well, not sent, I mean handed over by a thumb drive. So he's kind of got in his head where he needs to get to. But there's no sense that he's actually just telling you the truth. Now, he just had no answer for the question of why his earlier statements contradicted his later ones. The only thing he could come up with was he said, well, I was told to check my recent statements, but I wasn't told to check my older statements. But that doesn't explain why they said something different in the first place. There was no answer for that. And quite importantly, we consider, we deal with this at paragraph 65. He confirmed that at least some of the things he was saying not because they were true, but because he felt he had the documents to support his position. That's at paragraph 65. And so if you go through that, you will see, so subparagraph 1 is if we just focus on the underlining, he says, but for what I did not, so he says, I could recall that in the evidence, because there is no, when you demonstrated the evidence to the 19 or 21 modules that were generated using the frameworks and the tools, it's listed, and I could extract it from the public catalogue of Library of Congress. But for what I did not, there is no record on paper to say that, so that it can deliver that to the court. And it goes on to say, in order to make a statement in front of a court, I have to have some tangible proof to present to the court. And then I ask him over the page about why he said it was 2012. And he said, because I knew that it was from 2012, but I had to have, sorry, it wasn't, he said 2016, because I knew it was from 2012, but I had to have proof. Otherwise, I would be in this situation where you're telling me you're lying, but I found proof I presented to the court. So you knew when you wrote this statement that you created MCC between 2012 and 2015, but because you were concerned you didn't have the documents to prove it, you said you created MCC between 2016 and 2021. Is that right? In part. And we say that that is effectively an admission that he was knowingly giving false evidence to the court. But it also sheds light on his attitude, which is, in his mind, documents rule. And that is why, no doubt, we say he generated the documents that he did. He thought his case would be unanswerable because if you've got a document, you win. It's
yes. Would that be convenient time?
Yes, of course.
Yes. All right. Well, can we still adjourn till 11:45? Is that enough time?
Certainly.
Yes. All right. 11:45 it is. Yes. Can you hear me now?
I can. Thank you.
Yes. I'm sorry for the delay. I was just having some laptop problems, but please carry on, Mr. Montague.
Not at all. Thank you. I was dealing with Mr. Shehata. I'll just conclude with a couple more points. So the first is that on a number of occasions in his evidence, he accepted that he had lied to people. We deal with this at paragraph 83 and onwards. He initially accepted that he'd lied to the claimants about the registration of MCC in the name of HI Dubai. He later tried to say, well, actually, that wasn't lying. He said it's misleading. But if you're saying things to try to trick people into believing something that's false, it's the same thing. And we say the fact that Mr. Shehata sees a distinction is itself quite telling. He also admitted to misleading Ms. Heggie when he said, in answer to her question about whether MCC was registered to HI Dubai, his answer was supposed to be, and he admitted that was an attempt to mislead her. it's also relevant we say that he was convicted of forgery in Egypt. His approach to that actually is more illuminating than anything. I confronted him with it. He denied it. And then he later said that he denied it. The denial is at day 8, page 19, line 25 to page 20, line 2. But he later said, well, I haven't been convicted because I've appealed it, and the effect of an appeal is to cancel the conviction. So I was never convicted in the first place, which is a surprising way. It's not a straightforward way to explain historic facts. So we say Mr. Shehata was a pretty shocking witness. He was evasive, refused to answer simple questions. He often made long speeches. There are any number of examples, and we give some in paragraph 72 of our closing. We also say, and this is at paragraph 74 to 76, that despite giving 13 witness statements, he was still coming up with new arguments and explanations and factual assertions in the box. And these were, we say, pure invention just to fill gaps and inconsistencies. Now, I won't go back over that because we set that out in writing. I mean, Your Honour is going to be most influenced by undisputed contemporaneous documents, no doubt, and I'll come on to those in a moment. But ultimately, there is no documentary evidence which supports Mr. Shehata's account. There is documentary evidence, and in particular, the communications that were produced by the 4 witnesses that we produced. And I'll come on to explain those in a minute. But just dealing first with the origins of M+, Medica Plus. I mean, in a sense, that's of historic interest because the first Mr. Shehata admits that they were owned by Health and Sites Dubai. Medica Plus was owned, albeit he says now, well, some of the bits of it were not.
Can I just stop you there, Mr.
Yes.
Montague-Smith? Is it a matter of historical interest, or is it your case that MCC was derived from
Yes.
Medica Plus, in which case, if it's not a new and separate software,
Yes.
then doesn't the MCC belong to the owner of Medicare Plus?
Well, that's our primary case. Yes, I say it's historic, not for that reason. It's important.
Oh, I'm sorry, I misunderstood. I thought you were saying of not important.
No. It's important
that
it's important that Medica Plus is owned.
Yes.
By Health and Sites Dubai, and that's absolutely critical. But
and that is your case, isn't it? That it's a derivative of Medica Plus and HR Dubai owned Medica Plus.
Yeah, absolutely. Yeah.
Okay.
But the reason I said it was historic is because the way in which Health and Sites Dubai came to be the owner of Medica Plus is historic in a sense because Mr. Shehata admits that it was owned by Health and Sites Dubai.
Is that enough? Can I rest on an admission from? Well, does he admit that? Sorry, I put that badly. His case seems to be he invented it.
Yeah.
And he still owns it, although he gave something to Medica Plus. It's a bit obscure.
No, I think he doesn't explain.
When I said gave something to HR Dubai.
Yeah, no, I think he registered Medica Plus in favour of HR Dubai. He accepts that.
But registration, of course, doesn't give copyright, does it?
No, but in his evidence, he accepts that he did that. He gifted it, he says, to Medica. He gifted Medica Plus to HI Dubai. That's what he says.
Well, can I go back to tell you some of the things that I've been thinking on your case, the case from your witnesses? It seems to me it is either your case or there is a case that Medica Plus was first developed by Solutions Plus, and then in some way, and this is question mark, and in some way it then became the property of H.I. Dubai. But that process by which the copyright went from Solutions Plus to H.I. Dubai is a bit mystical, or at least it's
Yeah.
not express.
Well, it's not been the focus of evidence submissions and all the rest, because we are all content. We'd understood that the case is that Health Insights Dubai owns Medica Plus, or owned Medica Plus. And so, I mean, given that Mr. Shehata had said that in terms, he said, I developed it, but I gave it to Medica Plus. I gave it to Health Insights Dubai. And that is my case, that it was owned by Health Insights Dubai. So I don't think there is a live, we don't approach the case on the basis that there's a live dispute about that. Now, I agree that we haven't got chapter and verse about what happened in 1998. It's not that surprising that we're 27 years later and we aren't able to explain in precise terms how that came about. But I think this is one of the fallacies of my learned friend's argument, which is that in order to accept the conclusion, you have to be able to show in granular detail precisely how this came about. You know, the fact of registration is strong evidence of ownership, and it may not confer ownership, but it is strong evidence of ownership, one way or another.
So is this the sort of reasoning process that might lie behind it? It was first developed by the employees of, and therefore by Solutions Plus.
Yes.
When Solutions Plus became in some way morphed into, transferred to HI Plus, it's then said by people that it belonged to HI Plus, sorry, to HI Dubai. Am I to infer from that there was either an assignment or something happened which made effective at law the copyright coming to belong to HI Dubai? So in a sense, am I to infer from the fact that it was accepted by Mr. Shehata and others that the copyright in Medicare Plus belonged to HI Dubai, that there was a legal process by which that came about, albeit the documents aren't before us? Is that the sort of process that you
effectively? Yes, effectively, yes. And so you'll recall the evidence was that Health Insights Dubai was established specifically to develop and sell or market this product.
Yes.
And then it did that for 20 years. And so the idea that the copyright in the product remained with Solution Plus would be wholly inconsistent with what happened next. And so we can't, as you say, produce a document which shows precisely how that happened, but you can, I would suggest, be very confident that happened, given what happened next. Nobody is suggesting that Orascom, or Solutions Plus, continues to own.
I think you're right. Software. It was Orascom was the. I think Orascom was the corporate body, wasn't it?
The original corporate body, and then there was a corporate Solutions Plus body, I think, and then Health Insights Dubai was established, and then Health Insights Egypt was established. So obviously,
Miss Hosny was a little bit, if not vague, I suppose she really wasn't asked to, in a sense, explain the precise legal mechanisms by which Solutions or the assets of Solutions Plus became the assets of HI Dubai.
Yes.
And there are two ways. Am I right in saying there are two ways in which it could have come about? One is if there was a separate written assignment of the copyright. Another would be if there was a transfer of assets which specifically referred to the copyright when the Solutions Plus assets were transferred to HI Dubai.
Or if it didn't I mean, I don't know is the answer. I mean, I can see if there was a total transfer of assets which didn't
I
specifically.
put that to you because you might correct me, but my understanding of copyright law, at least under English and Australian law, and I think the same follows under Egyptian law, is that a transfer of all the assets without specifically mentioning the copyright is not sufficient to transfer the copyright, but it would need the instrument which transferred the assets to refer to,
I see,
amongst all the assets, the copyright.
I mean, I don't know whether that is a requirement. We've not looked at that, or was a requirement at the time. We've not looked at that, and the reason we haven't really looked at it is we'd understood that yes, there was a dispute about how it came about, but there was no dispute that the copyright ended up with Health and Sites Dubai. And so we've not investigated that. But I mean, if one,
you might need to revisit that in your reply, because if Mr. Doherty confirms that the defendants accept that HI Dubai owned the copyright, at least I think when HI Dubai came into existence, then that perhaps need not be taken any further. But
well, the way he puts it is he says, well, my clients don't seem to agree with that anymore because they wouldn't confirm which of HI Dubai or HI Egypt own M+. My case is and always has been that HI Dubai owned Medica Plus, and his case has always been that HI Dubai owned Medica Plus. Now, if he wants to change his case, we would say, well, you've got to do that before trial on something like this. I mean, if it really was going to be submitted that Medica Plus was not owned by Health and Sites Dubai, then that would have been investigated at trial. And so it's not good enough to say, well, there's some link in the chain.
I might need to go back and see what their opening submission said about it. I'm not sure if it was expressed, but.
Well, yeah, I mean, what is clear, though, is that the evidence from Mr. Shehata is clear on this. I mean, he says, I gave it to Health and Sites Dubai.
And would I understand that to mean that he did something which was an effective legal transfer of the copyright?
Well, yes, because he registered it in the name. He says he accepts that it was owned, as I understand it. I'll do, you may be right, and I can look at this in reply. I have to say, I mean, one can say, well, all right, there's a logical world in which there was no transfer of Medica Plus to Health and Sites Dubai, but where does that leave us? What's the result of that?
Well, I think the result is it remains. Well, let me just go back a step.
Yeah,
it's not inconceivable that what could have happened was everybody thought that the copyright was transferred to or became the HI Dubai's, but that they didn't take the legal steps that were necessary to effect that, which might have the result that it remained with Solutions Plus. And if Solutions Plus still exists, and we don't know, it would still own Medicare Plus.
I think if that case was being run, it would need to be put to Ms. Hosney, that might be the position. I think that is, I would say, not open to my learned friend. We can dig out the references in due course.
All right.
Yeah. I mean, for example, if we bring up C411, which is the sixth witness statement of Mr. Shehata. And so if we scroll down above paragraph 39, he deals with, see the heading, HI Dubai's ownership of M+.
Yes.
There's others. I mean, I think we would be taken very much by surprise by an argument that M+ was not owned by Health and Sites Dubai, given that it ran it, given that the case has always been run on the basis that that was assumed. But I can pull out the references to that in reply.
Yes, please. That would be helpful.
Yeah. All right. I mean, in terms of the development itself, I think, he says he did it himself. He says it was all him.
Yeah.
I mean, in fact, he produced a document. If we can bring it up, please, it's E31. And this is a document which I asked him about, which he had produced, which set out the installations of what was described as installations of Medica Plus, at least, with the copyright symbol against it. And that was a document that he produced. I mean, he denied that in the box. That was day 6, page 26, lines 25 to 27. Sorry, lines 25 to page 27, line 1. When it was pointed out that actually he had produced it, he changed tack and said this was all just marketing hype. But he had produced that to show when the first installations of Medica Plus had occurred, to say, well, it was before Health and Sites Dubai was actually incorporated. And the problem with that was that it shows that Medica Plus was a version 3 in 1996, and the original version was in 1990 under Erascom. That's further down on the page. So he was driven to saying that the document that he had produced to show when the first installations of Medica Plus had occurred was not actually accurate. The truth, we say, is almost certainly what he told everyone in his email, which is at E161, page 2. And if we scroll up, we can see when that email was. You'll recall that this was an email he sent to the claimants, 22nd of February 2021. And if we could go back to the message, please. They said in 2001, Medica Plus was under another Erascom company called Solutions Plus, under Asma Hosni as general manager. Health Insights did not even exist at that time. Asma was the one that made that registration, not me, as I was just an external consultant for leading the development at that time, as Solutions Plus was working in security and banking applications as well. So in conclusion, Medica Plus was registered under Solution Plus, and when Health Insights was first created, the source for Medica Plus was transferred to Health Insights, which was as well Naguib Sawiri's company, and Asma was the general manager for both, so they did not see any reason to make any changes. So we say that's a summary of an accurate contemporaneous summary of the truth.
And again, is it open to me to treat the admission or concession that it was transferred, the source for Medicare Plus was transferred to Health Insights? Is it open to me to find that that means legally that the copyright was legally effectively transferred by whatever legal requirements were required?
Yes, I think you can, because what he's saying, if you look at the third paragraph, is he said we've already started the process of making proper intellectual property registration under Health Insights Dubai. So that's not an issue now. So what he's saying is it was registered as being owned by Solution Plus. It was then transferred to Health Insights Dubai in a way which justifies its registration in the name of Health Insights Dubai. So he's saying there's a transfer of ownership. That's what he must be saying there.
Yes.
Now, we don't know precisely how that occurred. It's right. No one's looked at that. But in my submission, that is strong evidence that there was some mechanism for transfer. And if somebody's going to say, well, actually, the mechanism for transfer was not effective because it didn't identify the asset specifically or whatever, then they would have to make out that case in my submission. I mean, again, we are dealing with things that happened 25 years ago, more. And in those circumstances, it's not that surprising that we don't have chapter and verse on all of it. But there we are. So in terms of the production of MCC, I've made the point that it's a bit surprising that Mr. Shehata said he was solely responsible for authoring it, but he can't produce any documents to support it other than the video, which we say that doesn't really help him. And actually, if you look at the video, if you can bring up, please, I-16 and go about 24 seconds in, you will see that even the mock-up contained a banner saying copyright Health Insights. So you will recall he then tried to sorry.
Yes. Well, as I said, I know it's not for you to make the case for the defendants, but do you understand the defendant's case to be that MCC was a new system,
Yes,
not a derivative
yes,
of
well,
Medicare Plus, or it's not clear?
that's the case.
Yeah.
We say the evidence clearly supports that position, and I'll take you through that. So essentially, what we say about the facts on the development of MCC, we set out at paragraph 173 and onwards on page 90 of our closings. I'm not going to go through
your
that
case
detail.
that what MCC was taking Medicare Plus and putting it into a new platform, a cloud-based system, but that did not involve the creation of a new software for copyright purposes.
It has precisely the same function. It links into the same databases with the same user interfaces to the extent that they even use the same credentials to log in. The way it was developed, you heard this from the witnesses, was they took the workflows from M Plus and they recreated them in the HTML5 format. Now, no doubt there was added functionality. You know, there's and it's structurally and architecturally different in the sense that you're using a different language and it can be operated on a web base on a web-based platform rather than having to install it. And so it's a step change in functionality, but it's still doing the same things, using the same workflows. And one of the points that I'll develop is to say, software is not just about typing code. Software development is not just about that. And I think this was accepted. It's also about all of the business gap analysis that goes on, the identification of the user needs, the development of the workflows, and that comes at the beginning, but also at the end when you're testing and there's feedback in from the testing, such that you've got a team of people, all of whom are inputting in. And yes, the coding is obviously an essential part of that, but so is the gap analysis and so is the testing. And effectively, Mr. Shehata agreed with most of that. And it's very difficult actually to understand what the case really now is, because the case originally was I wrote it all, and you've got no one who can tell otherwise. And now the case has become I wrote the essential elements of it, and actually they were sort of structurally significant to everything that was subsequently done. But he does accept that, you know, he says we went through. I'll take you through some of this if I may. But just I would invite you to go back to the evidence of the 4 witnesses that we produced, Mr. Al-Shami, Mr. Bashir, Mr. Al-Shanawi, and Ms. Heggie, and at some stage read through what is relatively brief, their cross-examination, because I mean, my learned friend now accuses all 4 witnesses of lying, and he did not put that to them at any stage. In his closing at paragraph 42(3), he says they gave evidence on instructions from the claimants. We say there's nothing to support that. It was never put to the witnesses. It was never put to the claimants. It's simply not open to criticise their evidence on that basis. And indeed, actually, as you will see, if you go through that cross-examination, their accounts were barely challenged. Now, there's quite a lot, and I was just going to deal with some of the criticisms that are made of the witnesses, and then I'll come on to what you get from their evidence. But if you look at the closing, my learned friend's closing at 189. I mean, amongst other
paragraph
things,
189.
Sorry, 189, page 65. Yes, so sorry.
Okay.
So he's accused of so it's about 6 lines down. He's accused of giving misleading evidence at best, and then two lines further than that, it's carefully worded and probably not by Mr. Bashir. And then it's that form, and then final sentence, that form of misleading language is no better than lying. So none of that was ever put to Mr. Bashir, and it's based on a misrepresentation of his evidence. Paragraph 188, it's suggested that he wasn't involved in development, but he was giving the impression that he was, but he admitted ultimately that he wasn't. And that is not a fair account at all of what happened. It's a real mischaracterization of what he said. What he says, and we haven't got time to do this, and I'm going to run out of time if I don't crack on, is day 5, page 18, lines 8 to 23. He said he had 2 stints of employment with Health and Sites Dubai. And during the first of those, he said the roles were not well defined, and it was a flat structure. And he did have a development role. He said in terms he was in the development team. It's day 5, page 31, line 17 to page 32, line 2. And he gave evidence that there was no MCC in 2014 to 2015, and there was in 2017. And that's consistent with the claimant's case. Now, Ms. Heggie is criticised for much the same reasons at paragraph 191. She's also accused of misleading the court. That was never put to her. And again, the evidence is simply mischaracterised. So at paragraph 190, it said she had no programming background. That is wrong. She had an IT diploma, which included studying networks and software. It's day 5, page 81, lines 16 to 19. Paragraph 192 relies on the fact that she said she was not a software developer, but it totally fails to engage with the fact that she personally witnessed the development process. She was there. She said she sat with developers in different modules while they were upgrading to ensure that the modules functioned in particular in the appropriate ways. And that's at day 5, page 148, lines 9 to 17. And she said she saw the upgrading with her own eyes. It's day 5, page 149, line 4 to page 150, line 3. Mr. Al-Shami is also accused of giving dishonest evidence. It's closing paragraphs 197. And it's said that he concealed the fact that he is the brother-in-law of the second claimant, Mr. El-Shafai. Neither of those things were ever put to him, and he was asked about the fact that he didn't mention that he was the brother-in-law of El-Shafai. It was never said that he concealed that, and you'll see the cross on that at day 5, page 5, lines 13 to 24. And it was he confirmed it was no secret, and it was put to him. Mr. Shehata knew this. Mr. Shehata knew. So how is he concealing it when it's something that everybody knows? He felt it was not significant. So none of that is open to the defendants, but also it's not fair criticism at all. And at closing paragraph 202, He's accused of lying about the documentary evidence of the upgrade process, and we'll come back to that evidence, but none of that was ever put to him. The only basis that is advanced in these submissions is the mock-up, which my learned friend is mischaracterizing as a working demo of MCC, which his own client wouldn't support. But again, that was never put to Mr. El-Shafai. He was not asked about this. And again, his evidence is misrepresented at paragraph 200. So this passage complains that he thought VB6 was a tool. But the question in cross-examination was put on the basis that tool was the right word to use. He was asked about tools. That's day 4, page 197, lines 10 to 22. And then he's criticised for saying VB6 was the only tool he used when VB6, Visual Basic 6, was not used in MCC at all. Again, that is simply false. He said in terms, MCC, for MCC, we were using HTML5, Web API, and JavaScript. That's day 4, page 197, lines 10 to 22. And when he says he only used VB6, that's been taken totally out of context, because that was a discussion about Medica Plus. That's day 4, page 188, lines 10 to 19. So these criticisms, what's happening is that allegations of deceit, dishonesty have been put in closing submissions, never cross-examined on them, and they're based on a complete mischaracterization of the evidence that was actually given. And then 203, he's accused of saying MCC was all Mr. El-Shafai's idea. That's not what he actually said. When you read the passage, indeed it's recited at the foot of page 70 by my learned friend, the answer was at the bottom of the page. He is the one who came up with the idea, but he doesn't know whether this was with agreement with his partners or if it was just his idea. So clearly when he's saying came up with the idea, what he means is he's the one who produced the idea to us. He's the one who announced it, because it says in terms. It doesn't know whether it was just his idea. So this evidence is just being twisted. And he's accused of giving evidence that's obviously untrue. That's at page 205. But again, none of that is put. So what then happens is his evidence, they seek to minimize his evidence. They say he wasn't involved in development because he was employed by Al-Khalij until 2017, but he obviously was involved in development. His name appears on the list of developers in that spreadsheet, the Medica Plus Development Progress Report. You can see that at bundle E, page 83.20. And then there's all kinds of just inaccuracy in the way that he is then said to have expressed himself. It's said that he contradicted himself multiple times. There's a reference to there's a reference, in fact, to day 5, page 150, lines 17 to 23. And it may be my references, but that looks like Miss Heggie's evidence. The reference that we understand it should be to day 5, page 160. And he says in terms that he worked on some Medica Plus modules at Al-Khalij, others he didn't, and he converted some for MCC. So it is just false to say that he told the court he didn't work on MCC at Al-Khalij. So if you look at day 5, page 161 to page 162, about halfway down that page, he says he was at Al-Khalij during part of that period, and he worked on MCC and M+. And then there's the complaint 207 that he referred to the video as a video of a prototype, which is precisely how Mr. Shehata described it. And then there's the suggestion, paragraph 210, that Mr. El-Shanawi wasn't actually converting M+ to MCC. He was just customizing and implementing, and that was never put to him. You just can see that it's never in his cross-examination. So you have a false basis for a false allegation of perjury, which was never put to him. In terms of the factual material, the most significant document is this document at E83. Well, if we could start at E83, that's the email around, which provides the updated progress report sheet. But if we go to the attachment at E83.20, or I might recall this, which is the spreadsheet which sets out the Medica Plus development progress report. And this shows in real time what was going on in December 23rd, 2016. You see that at the top left. And it's still called Medica Plus, we say, because in reality, that's what it is. It's being upgraded to a web-based, to an HTML5 system. Now, how can we tell that? Well, first, because it says so. It calls itself Development Progress Report. Second, you can see it in the individual reports in the tabs. So if you go to the third page of this document, please, just by way of example, you've got Mr. Nader Galal reporting on the progress of development. You've got VB6 in one column, which everybody agrees is Medica Plus and not MCC. And you've got .NET and HTML5 in the other columns, which everyone agrees is MCC and not Medica Plus. So this is recording the progress in upgrading Medica Plus to MCC. What does my learned friend say about this? Well, he says that this is a single project for a group of hospitals. That's his closing at paragraph 216. And he cites what he says is evidence in support of that, which is an extract from the cross-examination. But he is misrepresenting that evidence too, because actually where that comes from, when you go back and read it, and the references to day 7, page 4, lines 3 to 5, Mr. Shehata was saying, we say falsely, that Medica Plus could be multi-tenant. So you can have multiple hospitals coming into it. But he said that that had been done in a previous different project in the past. He said, I did it in Malaysia. He accepted in terms that these spreadsheets were not related to a specific hospital. That's day 7, page 37, lines 8 to 18. The evidence which is being relied on is an attempt to explain away the reference which we see to this being a multi-tenancy project, because being multi-tenancy was one of the key innovations associated with the progress to MCC. And Mr. Shehata himself had pointed this out in his witness evidence. That's at C422. In his 6th witness statement, he identifies the differences. And one of them is, well, MCC is multi-tenant, whereas Medica Plus was not. And when he was confronted with this, he changed his evidence and he invented a new explanation about a group of hospitals that he had undertaken. And he even used the word we, even though he said he was also simultaneously saying that he did everything of substance. Well, once you accept that this document that we're looking at is not in relation to a single installation or a group installation, but a particular project, once you accept that, which he did, and once you accept, as it states, that it's multi-tenancy, that it's only consistent with this being about developing from Medica Plus to MCC. And similarly, the reference to HTML5. Now, of course, Mr. Shehata was driven to say that he incorporated elements of HTML5 into Medica Plus personally, but that couldn't explain why you've got here a team of developers who are using HTML5 in every single element of the software in the spreadsheet. So my learned friend says at paragraph 181 of his closing that these spreadsheets on their face state that they relate to the implementation of Medica Plus. Of course, there is no reference in that paragraph to any document, but that is not true. We've seen on page 1 of this that it calls itself a development progress report or an implementation progress report. And this is all consistent with the later messages, which show that the continuing development of MCC over time was undertaken by the group. And we set that out in paragraph 182 of our closing. Mr. Shehata was asking developers to send him code and to list the modules that they were working on. And if we go to bundle E, page 209, tab 7. So E, tab 209, page 7. You'll see an example. You could zoom out and scroll down a bit, please. You can see engineer Nasser says, I'll consider if no active development that you're now to be free to be assigned tasks. So the idea that there was, I mean, his position is that there's no development team doing anything. He's doing everything. And yet he's here. This is sometime later, but he is here saying, well, look, if you're not developing anything, I'm going to give you something to develop. It's just inconsistent. The documents are totally inconsistent with him complaining that there were no developers available, for example, at HI Egypt. And it's all consistent with the claimant's witnesses. And they give a straightforward account of using the workflows from Medica Plus to develop MCC. As I say, Mr. Shehata accepted that process in principle. If we look at day 7, page 57, at line 11. Oh, damn. Bear with me. I'm afraid I've been using the transcripts on the system.
Yes.
To provide me with this assistance. Yeah. We go down. Can we zoom out and go down a little bit? I'll be able to find the bits that I think are right. Well, if you read these, it's not far off. So if you go through these bits, so we're looking here at essentially page 57 of day 7. What you will see is that he describes using Medica Plus and seeking to replicate the workflows in the MCC modules. And in the course of that, it's probably over the page. In the course of that, he says, we did it. And that we I'm sorry, I'm not in control. If I was in control, I would be able to show you the relevant bits of the transcripts. I do apologize. I didn't realize that this transcript was the finalized one. I thought we were working from the ones that were actually on the Flow Smart system.
Yes.
But if it's possible to do that, that would be better, but never mind.
Can we scroll down a bit? Does that work?
Yeah, so so if we go up, actually, sorry, he says, I disagree. Yeah, we are. I disagree. No, not that far, please. Just down a bit. Thank you. I disagree and agree at the same time. I already said the active medical sheets framework and the rules at work we used in Medica Plus called function development. By development, I say configuring and things. So to move the same to MCC naturally, you would have to open that module, if you might, in Medica Plus. That is on top of the active medical sheets framework. Follow the steps that are going for the workflow, and then try to replicate that using the tools that are much stronger, that are available in the Dynadocs and the Rules of Work toolkit for MCC, which I developed. And he confirms, if you go down, please, scroll down. Right, there are general functions for any healthcare system. Keep going, please. So what was existing in Medica Plus might resemble the same, or we might have changed some of the workflows or logic to overcome some of the deficiencies in the workflow in Medica Plus. So he's saying, you might make some changes, but you start with the original workflows. You start with effectively replicating the modules from M+ in MCC. And then I make the point that he said we, and I ask him about who we is, given that his case at this point is that he did it all himself. And then he says some people. This is further down, and eventually he accepts that it was Health Insights Egypt people who did that. We might have changed some workflows, and you can see that further down. So we say, when you look at the evidence of the 4 witnesses and you match it up, there isn't actually much between them in the physical question of how MCC was produced. You take Medica Plus and you just replicate it effectively. And the other point is that, as I mentioned, software is more than just coding. You'll recall the explanation of the gap analysis, and he accepted that is an important part of developing software. And he disagreed with Ms. Heggie about whether there was any market research that was actually done. She'd said we'd done that. But regardless of that, there was work done. There's a whole department in the company whose job it is to develop identify the needs of the customers and develop the workflows which are then going to be implemented into the software. And he accepted that testing was also important. I've got it on page 69, and I doubt whether that's right or wrong, but there we are. And so I asked him, well, okay, the development of this software must therefore be a group effort, even on your case. And he just refused to answer the question. So all that knowledge and development from the prior software, which, as we'd understood it, the defendants accepts belonged to Health Insights Dubai, was used in developing MCC. And against this, what have we got? We've got now, the original claim was he did it all himself, and now we've got this unsupported assertion that what truly matters were the rules at work and Dynadocs. And the unsupported assertion that Mr. Shehata developed them and owned them. And it's a bit surprising, we would suggest, that was said for the first time in the 13th witness statement a few days before trial, this focus in on these two bits. And it is a shift from the previous position that he wrote everything. And he previously identified rules at work as a module and Dynacs as a module. Those are on pages C, tab 4, pages 23 and 24. He listed those things. So that there's an issue about who actually created those. And all we have is Mr. Shehata's assertion that he did. But if they were so important, you would see them somewhere in the development progress report, for example, or in the documents somewhere. And there are no other references to them in the documents, apart from one isolated reference in a WhatsApp to Dynadocs, which doesn't shed any light on anything. And we say it's not credible. So where do we get to on ownerships there? We say there is plenty of evidence that the second defendant owns MCC, some direct from the development process itself, some indirect from the interroco certificates and from statements which were made at the time. And we set this out in our closing, page 133 and onwards. And I went through, I'm not going to trawl, I don't have time to trawl through all of it. But the first and primary point we say is that MCC was just a new version of Medica Plus. There's obviously significant changes, but fundamentally it's the same software doing the same thing. The second point, as I say, is that development is not just about coding. Business development side was just as important, and it identified what was required. And that was undoubtedly not carried out by Mr. Shehata. Much of the development was by developers working for Health Insights Egypt, but we can see Health Insights Dubai paid Health Insights Egypt for software development. We know that. For example, if we bring up E134, tab 134, page 23, this is just an example, there are others. You can see in the financial statements for Health Insights Dubai, payment for software development in Egypt. So You can see that, for example, in 2018 and 2019, but it's in every other year. We don't have the documents. We don't have the documents to cover those payments because Mr. Shehata was in charge, and there's nothing left. But structurally, if one looks at those facts, that is consistent with Health and Sites Dubai engaging, in effect, Health and Sites Egypt to develop for Health and Sites Dubai. And so that's one other way in which the ownership of this software could have come to be with Health and Sites Dubai. And given that Medica Plus, if you accept that, was owned by Health and Sites Dubai, it would make sense that the party's intentions were that Medica MCC would also, if it's a separate piece of technology, would also be owned by Health and Sites Dubai. That was the entire business. It was serving the same function. The idea was to transition from Medica Plus to MCC. And so unless there was to be some radical trailing off of the business of Health and Sites Dubai, it makes sense that everyone's intention was that MCC would also be owned, if it's separate, by HI Dubai. We have the registration with Interoco, that's at E24. My learned friend says, well, that doesn't legally affect a transfer, but it is compelling evidence that the development was being done for the benefit of Health and Sites Dubai. It's evidence of ownership. It may not create ownership, but again, one can infer that one way or another, ownership was with Health and Sites Dubai. Now, in relation to the Interoco certificate, so it's E24, please. What's said about that is that it only covered part of the code. So this is one of them. There's three of them. One's for the UI design, one's for the source code, and one's for the brand. So there's this argument that's being run that actually all that was registered was a small part of the code, just a very few modules. And you can see that that is not right, we say, when you actually look at those certificates. I'll come back to that in due course. But if, for example, you go to bundle E tab 95 into the second page of that, you see the written statement that was deposited with Interoco. And the second page of that, you see the name is Medica Cloud Care. It's a software program. And if we go over the page, you'll see the legal owner, intellectual property rights company name, Health and Sites FZ LLC. And that's what was deposited with Interoco to get the certificate that we've just seen. And so, and then there are contemporaneous documents which support the conclusion that the intention of the parties was that Health and Sites Dubai would own the copyright. So there was the collaboration agreement, for example. I don't know if you recall that. That's at E125. If we zoom out on these, please, and then go down to page 4. You can see it's a collaboration agreement, and you will see B, HI specializes in the area of comprehensive healthcare solutions, including solutions related to electronic medical records and hospital information system, i.e. the flagship healthcare information system, Medica Cloud Care. And then if we go down to clause 5.1 on page 7, it talks about HI's intellectual property. And you will see 5.3 deals with how that ownership is retained, and the language in red was inserted by Mr. Shehata himself. So you'll see, for example, he's inserted the words, while core product components ownership remain the sole intellectual property of Health and Science. So he's clearly, this is coming from Mr. Shehata himself. You've got well, I won't go through the whole of what we rely on, but there are various other things that we rely on. There's some emails, there's WhatsApp's Inter-ACO questionnaire. The assignment agreement itself, of course, says the Health and Science Dubai owns the software. We've got those WhatsApps with Ms. Heggie, where he said, it's supposed to be. And there's various other points relied on. So we've got this position whereby consistently Mr. Shehata is telling everyone that the Health and Science Dubai owns this software. He's the one who is in charge of both companies, Egypt and Dubai. Why is this relevant? Because the test for what amounts to a collective work appears to be essentially agreed. You can see it in our closing on page 130. And we recited it, subparagraph 2481 is the Egyptian version, and it's the same under UAE law over the page. But essentially, what is required is you need a group of authors on the instructions of another person, which can be a legal person, which undertakes to publish the software in its name and direction. And the contributions must be integrated into the general objective so as to make it impossible to distinguish their individual contributions. And we say that if we get here, so this is if this is a fresh piece of software for which isn't a sort of development for hire situation, there's the first two possibilities. What is it? And we say it's clearly a collective work done for the benefit of Health and Science Dubai. Now, the main point that is made against us in submissions is that this argument can't work because the first defendant wasn't involved in it personally, because he was in Germany at the time. So if you accept I think the point being made is, if you accept that these spreadsheets that I've shown you from December 2016, early 2017 are development of MCC, then they're not being directed by Health and Science Dubai. Why? Because the first defendant wasn't involved, because he was in Germany at the time. Now, our position is, of course, that he wasn't involved in actual coding, but he was still the CEO of both Health and Science Dubai and Health and Science Egypt. And Dubai is still paying fees for this software development. So while in a vacuum, there could be room for doubt about which of those two entities was the one which it was intended would publish the software in its name. There's no doubt it was one of those two, because this is obviously under the overall direction of Mr. Shehata. This isn't just something that the employees have gone off on a frolic of their own to do. Mr. Shehata is responsible for the companies as a whole, and this clearly was on his instructions. No one else could have done it. So the question becomes, well, all right, he's in charge of both Health and Science Egypt and Health and Science Dubai. He's instructing Health and Science Egypt and Al Khalij individuals, personnel, to produce MCC. Which company is he instructing them to do it for? You can see that there's a question that might arise about that. But as to which of them it is, we say that's answered by all the points that I've made about the documentary evidence and the intention of who would own MCC. So we say it must have been Health and Science Dubai, because as you go through, all of the contemporaneous documents indicates that must have been the intention. And ultimately, that is where it was registered by Mr. Shehata, who was directing all of this. As I say, what would be the result if I'm wrong about that? So say this is a fresh piece of software. It's been developed by all these different people. What's the answer? The answer would be, according to my own friend, presumably, each individual contributor owns their own little piece of MCC. And that would be a very strange result, and one you'd have to be driven to in my submission. But even that wouldn't work. Why not? Because you can't actually, it's not possible to say, you can say these 3 people worked on a module, but that module is the product of other people's work as well. So there's the fact that they're writing in code doesn't make that, it's not the beginning and the end of the development of that piece of software, that module. So what we say is whether you approach it on the basis that MCC is a new version of Medica Plus, whether you approach it on the basis that all this work was being done for hire effectively by Health and Sites Dubai, or whether you approach it on the basis that it's just a standalone piece of software that counts as a collective work, we would suggest that the case is strong and overwhelming, that this is software which belongs to Health and Sites Dubai, and really the only thing that there is against that is Mr. Shehata say so, and the video at I-16, which really doesn't do what my own friend says it does. That leaves me about 25 minutes to deal with the rest of the issues that arise. So I will do that as quickly as I can, and I may run out of time, but we do have comprehensive submissions on all of this. Yeah. That was ownership. The next issue then is the purchase order a genuine document? And we set out our position in relation to that at page 142 onwards. We say the document is not real in the sense that at the very least it was backdated and it wasn't intended to create a contract on the terms that it states. The purchase order is at E74. We've looked at it briefly, but let's get it up. And we make a number of points about this. If you can zoom out so we can see the whole thing, that would be helpful, please. Thank you. So it purports to relate to the development of MCC generally. That's what it's. And you can see why it's been put there, because I think the underlining of as work for hire is to make it clear that because it's purporting to say Health and Sites Malaysia is paying for it, paying HI Dubai to do it, that means the ownership comes to HI Malaysia. That appears to be what it's intended to do, and it was produced to support HI Malaysia's ownership. It sets a price of $1 million. I think you see that on page 2, and it provides for a delivery date by the end of the year.
Mr. Montague-Smith, can you please just let me pause for 1 minute? I just have to attend.
Of course, you're on mute, but of course.
I was going to ask you, I need to pause for 1 minute.
Yeah,
please don't go anywhere, but I just need to pause for a minute.
Of course.
Thank you. Sorry, I don't want to continue on here, so just put. Yes, please continue, Mr. Montague-Smith. Yes, can you hear me?
I can hear you. I'm so sorry. I muted myself.
I'm sorry for that distraction.
No,
please continue.
Of course. So we're looking at the purchase order. If we scroll down to the second half of this page, you'll see the purchase price is set at $1 million. And it provides for a delivery date by the end of the year. Sorry, my instructions to the EP are not following through too well. I'm so sorry. So all work delivered by the end of 2016. So it's purporting to say that the whole of MCC, we would say, is developed between July 2016 and the end of 2016, when in fact we've seen the progress report shows that it's being developed in December 2016 into 2017. And we can see that from the spreadsheets, and indeed development went well beyond that date. Now, it's quite, so if you accept the evidence of the progress report as being evidence of the development or the change, the upgrade, if I can put it like that, then why is there a purchase order being issued for a different time period from Health Insights Malaysia to Health Insights Dubai? And how would that work? Because Health Insights Dubai only has 4 employees, so it must have been about the development by Health Insights Egypt. And so in a way, it's implicit in this document, actually, that without the document, it would be Health Insights Dubai that would own. Otherwise, why would it be there? But in any event, we'd say it's clearly not consistent with the facts of the timing of development of MCC. Now, in evidence, Mr. Shehata claimed that it didn't cover the whole of MCC, just as he put it, a tiny proportion of the modules. But that is not what it. That's not what it says. It includes all the submodules, and it defines it in broad terms. So immediately, it appears to us the document is not actually, on his case, intended to do what it purports to do, because he says, well, it's intended just to be in relation to his tiny proportion of the modules, but it doesn't say that. So that's why we say, in essence, and we refer to the transcript references, that essentially his admission amounts to saying it is a sham document. It's not intended to do what it says it did. It's very difficult to see what effect my learned friend now relies on this document for, because his case is nothing was owned by Health Insights Dubai, or could have been owned by Health Insights Dubai, and his case is that nothing, as we understand it, was owned by Health Insights Malaysia. So what is this being relied on for? Is it being relied on? It's important that there are no contemporaneous documents which could tell us when it was created. We don't have any emails. According to Mr. Shehata, it was the product of 2 people. That's himself and Mr. Hanafi. And in cross-examination, he said, Mr. Hanafi, I asked him about the date. Did you insert it? And he said, no, Mr. Hanafi inserted the date. That's day 7, page 188. But we've got no record, he says there is no record of it ever being sent between them. And then the other aspect of this is, if you look at the other version of the purchase order, which is at E60, tab 60, page 29 is the relevant part. We can see that the stamp there appears to have been digitally added somehow. So the document appears to have been manipulated in one form or another. We scroll down, please. You can see there's a white border around the stamp, which can't. This isn't just simply a stamp being applied to a black and white document. It looks, you can almost see a white outline around the blue. So unless somebody's using actually white ink, there has been some form of manipulation of that document one way or another. The only independent record of any sort of this happening comes in bank statements, because Mr. Shehata says, well, the purpose of this document was to inject cash into the company because it didn't have cash. But we set all this out in our closing. The point here is that the invoices that he relies on were dated October and November of 2016. So he says there's an urgent need for cash, but we don't even invoice for 5 months, for 3 or 4 months. and then the money doesn't come in until the following year. So the money actually comes in October 2017 and February 2018. So, and that's what the bank statements seem to say. So the story is that this was created as a basis for an urgent cash injection, but the cash wasn't actually sought for 3 or 4 months, and it wasn't paid for 15 to 18 months after that. And there's no explanation of why you would need a contract to cover a cash injection. Why do you need to? Why this elaborate ruse of a purchase order when all that's wanted is some cash? You just put the cash in and then cover the terms of the cash injection. So all we have to support this are as I say, the bank statements, and those have been heavily redacted. They're at tab 60, pages 32 and 33. You'll remember the ones that when you see them. And so this is what's being said, is that they came in 2 chunks which don't actually match the invoices because they had to split them out between the invoices. So we say this is really just a sort of retrofitting the evidence to the case, and everything else has been redacted. But you can see that's coming in. The post date is on the right, 30th of October 2017. That's the first payment, and the second payment's on the next page, page 33. The other thing you can see from these statements is that there's plenty of cash in the account at the time. $3.7 million at that point. So that this idea that there was a real need for cash injection doesn't make any sense. Ultimately, this purchase order is just inconsistent with the case that's now being advanced, because it's about to support Health and Site Malaysia's ownership, which has been abandoned. So it sticks out from their own case. And we say that supports the conclusion that it was generated for the purpose of the case as it was then being advanced. The significance of it is somewhat reduced now that it's not being said that this covers the whole of MCC, but there we are. So if I'm wrong about all of that, I'm completely wrong, then what does it actually do? It doesn't deprive Health and Sites Dubai of its ownership of MCC. The next issue then, if it arises, is whether or not it's void for want of authority. Again, the significance of this rather diminishes, because if I'm wrong, then this is only a small proportion of the modules. We set out our position on this on paragraphs 284 and onwards. It's on page 146. And we make the point that the central principles when it comes to this cluster of issues is, firstly, as a director, Mr. Shehata's authority was limited to doing things which he believed to be for the benefit of the company. If he knew he was not doing things for the benefit of the company, then he had no authority, actual authority. And if Health and Sites Malaysia knew those relevant facts, then there could be no apparent authority either. And so essentially the question on this footing would be, did Mr. Shehata know that the agreement was not in the company's interests? And we say on its face, at least, it plainly was not, because the language effectively transferred ownership in MCC for $1 million. And we say that was an obvious valuation. It was effectively selling out the whole of the company's main assets for a very small amount of money. We've set that out in a bit of detail. I won't go through it in too much at this stage. If we're wrong about it being void, then there's a question that arises as to the application of the regulations. There's a prior issue about which version of the regulations apply. There's a timing issue there. I don't know if you've seen this, but yes, the regulations. Yeah, so the regulations in their current form came into effect in February 2017. Now that is after the document, this purchase order is dated, but it comes well before any of the payments. So if in fact this document was created around the time of the payments, then the existing regulations are in place, and our closing, page 150 onwards, sets out what we say about the approach under the current regulations. And there's a series of questions. First, is the director interested in the transaction? Second, did they make a declaration? And third, if not, what is the sanction? And we say clearly Mr. Shehata was interested because it's a contract between him, he's causing Health and Sites Dubai to enter into with his own company. He didn't make a declaration, no one says he did. So what is the sanction? The court can set aside the transaction and order an account. If we get here, we say the court should do so because he decided the price, he controlled the transaction, it's an obvious undervaluation. To the extent this did anything, it was essentially an exercise in stripping Health and Sites Dubai of its assets. If the purchase order is real and was concluded before February 2017, then the previous regulations apply. We say it makes no real difference and none to the outcome. I'm not going to labour all of that. We say the court is very unlikely to get there. And given the competing factual cases, the significance of the document may be quite limited. Later in their closing, the defendants say that the purchase order cannot be rescinded because it was performed or because it was affirmed. That's their closing 268 and 269. It said it's not disputed that it was fully performed. I mean, of course it is. My own friend's own client says that the second defendant didn't actually do anything. I mean, essentially, his case is that there was no work done pursuant to this. But anyway, but I mean, the bottom line is A, you can't affirm a void contract, and B, you can't affirm a contract you don't know about. And there's no suggestion my clients knew about it. The assignment agreement is rather more significant, albeit the defendants seek to limit its function. We accept the assignment agreement was genuine in the sense that it was created around the time it is dated, because the claimants first became aware of it when they were shown the Interroco certificate in favour of HI Malaysia. And that was shown to them by a customer, and that led to the inquiries with Interroco, and that revealed the assignment agreement which had been filed in October 2021 and registered in December 2021. So it was created to support the assertion that Health and Sites Malaysia owned MCC. And that came about at a time when the relationship was deteriorating. This is late 2021. You may recall that the claimants had told the defendant that he needed to improve his performance or be replaced. Now, my own friend says there's no evidence of that. There is. If we could bring up Q, I mean, it was mostly done by conversations, but you can see it. It's Q3, Q tab 3, and there's a WhatsApp exchange. Sorry, Q tab 3, please. If you scroll down, please. Thank you. So you say, you can see there, Mr. Thamer saying 10-12. Nevertheless, I gave you my word, Abu Saif, that I wouldn't make any decision until the end of the year. For your information, you asked until the end of September, and I told you you have until the end of the year. So they're discussing how to move forward with the company, and this entirely supports the claimant's account. Effectively what they were saying was most of the business was being generated through Al Khalij. So 90% or something of the business. So actually the first defendant had done very little to take forwards the business. Now on its face, the assignment agreement is at E200 page 2. The assignment agreement purports to sell the entirety of MCC for $500,000. And if you go through the assignment agreement, we make some points about the terms which are not consistent with this just being a part of it. So it said it's not a derivative work, no other person was involved. This is clause 4. But it defines what was assigned by reference to the Interroco registrations. And I've shown you briefly, if we go to E95, page 2, please. This is the application to Interroco. We've seen this very briefly, shown you, scrolling down, we can see Medica Cloud Care as a software program. If we go to page 3, thank you, and scroll down, you see at rows 6 and 7, the materials to be registered software source codes, the type of material, electronic archive of the full source code. So the description is totally inconsistent with this being about 7% of the modules. So looked at objectively, this agreement was purporting to assign the whole of MCC. And we have this explanation that this was also done because Health Insights Dubai needed cash. That also is false. It doesn't stack up with the accounts. We set this all out in our closing. It doesn't stack up with the what we know about what was available to the company. In reality, we say this was just part of the exit strategy at the end of 2021. So he knew he was going. He hadn't improved the performance. So he set up a new company with the same name. You'll recall, Health Insights in Arabic. He poached the staff, and he sold the IP, and he took everything that wasn't nailed down effectively, and left nothing. He emptied the bank accounts, as we'll come on to in a minute. And we say that his response to these proceedings is simply a continuation of that strategy. So the first question is whether it's void for want of authority. My learned friend says I have no standing to say that. That's obviously wrong. It's an issue in the claim. Why is it an issue? Because if the assignment agreement is void, then the court cannot set it aside under the regulations, as we've discussed in opening. So the court needs to decide that issue. And as to whether there was authority, we say there plainly was not. We're back to those principles, but obviously Mr. Shehata was in a position of conflict, and $500,000 for the whole, sorry, $1 million for the whole of, sorry, it's $500,000 for the whole of MCC is plainly insufficient, and he accepted that himself in cross-examination. But he selected the sum that was to be paid. So this was just a misappropriation of Health Insights Dubai's main asset in secret at an undervalue. And we say if you get to that point, if you agree with me, then Your Honour should make a declaration to that effect. The points made against this in closing are paragraph 82 and onwards, sorry, page 82 and onwards of my learned friend's skeleton. And he makes various points. 82, the first 2 points, one is about, well, no work was done. Sorry, 251 is about, he says MCC was not developed by HI Dubai. Compare that to his submission that the purchase order has been, the work has been completed, but there we are. That's irrelevant. What matters is who owned MCC. And he disputes that at 252. So that's the central complaint. He says, well, there's nothing that's actually transferred. I point out here, though, that the defendant did accept that something was transferred by the assignment agreement. He accepted that at day 7, page 169, lines 16 to 18. And at paragraph 253, they rely on the partner reseller certificate, which they say is not challenged. That's not true. But the case makes no sense. The certificate's not a license. And then fourth, they repeat allegations about threats. They don't repeat the allegation of blackmail. You may recall that. And the evidence is not referred to, of course, but you may recall the email exchange. It's at E160. And you'll recall Mr. Shehata calling it blackmail when Mr. Thamer said, we're not going to place any more business with you until we see the IP certificate. Mr. Shehata said, he said he was going to register MCC in Health Insights Dubai's name in response to this email, but he got the order wrong because he'd said it, and then the email from Mr. Thamer, which we still haven't got up on the page, it's E160, please, came after the statement. Thank you. So we say it's void for want of authority because he's self-dealing in a way that he must have known, and therefore Health Insights Malaysia must have known. If it's not void for want of authority, it should be set aside under the regulation 79.6, and we've set out at page 159 why we say the requirements are satisfied. And I mean, the response to the claim is, well, there's no conflict, which we find a bit surprising. That's for closing para 261. Then there's the repeat allegations about the threats at 262 and so forth. And we deal with that, the stuff about the threats in our closings at page 85. I won't go back to that. There's reference at 1552. There's a mischaracterization of what we say. There's essentially they say, well, we always knew about Health and Sites Malaysia, and we deal with that at page 85 of our closings. But there is a mischaracterization.
It doesn't really matter, does it?
No, it doesn't. Because we didn't know about the contract, and that's what we need to know about. Yeah. So, excuse me. But I do say there is at 1552, there's a mischaracterization of what my clients actually said about this. They didn't say they only found out about the company in 2022. That's just not true. And that's not what the claim ever said. And 175 just ignores everything that we went through with Mr. Shehata about in cross-examination. So they ignore all his answers. They say, well, the claimants travelled to Malaysia. He accepts that one of them didn't. He accepted that it wasn't anything to do with Health and Sites. It was all about a different company from Mr. Al-Shafai's son-in-law. So ultimately, we don't see any answer to the clause, the article regulation 79 argument. If you're with me that that MCC was owned by Health and Sites Dubai. Now, I'm conscious I have not yet told you anything about the payments claim. I probably would like to spend about 10 minutes on that.
Yes.
But
all right, do that.
All right, I'm very grateful. Thank you. So we say that the payments claim is very clear. Mr. Shehata admittedly emptied Health and Sites Dubai's bank accounts into his own bank accounts between September 2022 and August 2023. And the total removed was $845,000, 269. Now, he's tried to justify this, but we say his justifications don't withstand scrutiny. And we've set that out in a bit of detail in our closing, but the starting point is, if you're a director and you take your company's money, of course you have to account for it. That's just there's just no two ways about it. The first thing we are met with is another pleading point, and that's at defendant's closing paragraphs 273 and onwards. The essential complaint is that while we plead that he took the money, we don't plead out breaches associated with his use of the money. And that's totally misconceived. The breach is in misappropriating the money. The obligation to account arises immediately on that appropriation of the cash. We don't need to plead further breaches in the use of it. He accepts he took it. It's for him to plead and prove that he used it legitimately, and then we test it, and we rely on a case. We rely on a case which is Re-System Building Services Group in liquidation, which you'll find at H38. H38, please, page 41. Page 41, and it's paragraphs 214 to 215. 41, please, 41. Thank you. 214 to 215. Can you get those up? Sorry, can we see the whole of 215, please? Thank you. Yeah, thanks. And then, so just the punchline is at the bottom of paragraph 215. It follows that once it is shown that a company director has received company money, it's for him to show that the payment was proper. So it's said there's no suggestion in evidence that he misappropriated money. You see this at paragraph 276 of the scope of their closing. None of C's trial witnesses advanced arguments that D1 had taken or misappropriated HI Dubai's money. And then they quote 277. I mean, it's a bit odd, because they actually, just look at the quote. It says, I do not know any legitimate reason why Nasser would have made such withdrawals, and I believe that he has misappropriated these funds. I mean, They say that it's not alleged that he's misappropriated the funds, and then they quote a passage where it says he's misappropriated the funds. There is an attempt in the closing for the first time to link the closing of the HSBC account, which triggered all of this, to police complaints made by Mr. El-Shafai. This relies on, we say, on mischaracterization of his evidence, in part because at 278 they say he refused to give the date of the police complaint. That's in the middle of the paragraph. That's false. He said in evidence that he couldn't remember the date, so he didn't refuse. But in any event, this causative allegation is made for the first time in closing. There's nothing to support it. If you're worried about the pleading is at B tab 3, page 9, paragraphs 42 and 43, where we make clear that we say there is no legitimate basis for the payments. Nothing more is required. And on the facts, when it comes to looking at this, we say the submissions just ignore what happened at trial. So paragraph 283, it said, this is the bit, it said, well, all the funds were fully accounted for in the ledger as accepted by C2. That has no relationship at all to what Mr. El-Shafai actually said. There's no reference to a transcript. I've found it, what may be what they're talking about, at day 2, page 103. I think it's line 23 onwards, but it probably isn't in this. But in any event, there is nothing in there about the second claimant agreeing that the funds were properly accounted for. What he said was there was no handover. I can't know whether it is or whether it isn't. The point here is that this was all justified by ledgers, which were not independent documents. And the ledgers didn't match the transfer slips. And as we point out in our closing, Mr. Shehata accepted that, as he had to, under cross-examination. That's day 8, page 184, lines 9 to 13. And then page 193, lines 7 to 16. The next point that's made is it said, well, the first defendant was never asked, this is the second sentence, was never asked to disclose his correspondence with the auditors. That's false. He was ordered to. You'll find the order at bundle F, tab 6, page 4. It's request number 10. And that was an order that was made. Paragraph 284, it said this is all supported by documentary evidence. But that totally ignores what happened when that was tested. And we deal with that in our closing, paragraph 337. Fundamentally, there's no independent evidence whatsoever to support his salary payments claim.
When you say that, was he not entitled to salary up to the time of his removal as the general manager?
Yes, that's right. But what he says is he didn't take that, so there was an accrued entitlement, and then he just takes it all out in one chunk. And that's how he justifies. So yes, he's entitled to salary up to May 2023.
Right.
And there's two problems. One is he then just takes a big chunk of money and says that's just past salary I'm owed. And the only justification for that in documents is he says, well, he says this is supported by the year-end 2021 accounts, because they show management entitlement at that date. But if you go to them, they don't show that at all. If you go to document E, tab 371, page 20, please. There's no cross-referencing again. So we've had to do this. Well, I've had to do this without a junior, I'm afraid, on my own. But E371, 20, this is what I think is being referred to, because you'll see general expenses, managerial remuneration, and there's 2020 is 657,540, and then there's a blank in 2021. So it seems to be being said that somehow that supports the case, that there was an accrued debt to him that wasn't paid out. But this is not a cash flow. This is about debts being accrued. These are sums that have been incurred. So if anything, 2021 seems to be suggesting that nothing was incurred in relation to managerial remuneration. And this is only up to the end of 2021. So how you link that to the payments, the past payments, to him just taking the money in September 2022 is just down to what he says. So that, and then as to the rest of it, you've got also claims for payments after May 2023. So if we look at his ledgers 362 and 364, you've got payments claimed for September, well, all the way up to May 2024. So part of the problem is that he didn't produce his bank statements. So we asked him to produce the bank statements, and you could go back through those bank statements. And the whole purpose was we could interrogate them and see what he did get. And he was ordered to produce them in no uncertain terms, F13, F tab 13, page 2, and it's paragraph 24A. And his answer to this, when asked about it in cross-examination, was that he thought the bank statements meant transfer slips, and that's why he hadn't produced them. We set that out on page 63 of our closing. And it's totally incredible, we say. I mean, you can see the transcript in our closing. And eventually he accepted that he knew what bank statements were. So, I mean, you know, it said bank statements, it didn't say transfer slips. It's the idea that he hasn't produced any of the documents which could have helped us. And we, again, just have to take his word for it, that while he was in control of the company, he didn't pay himself this money. And even then, you know, when you get to the ledgers, the source of those ledgers has become even more unclear, because council in their closing at 284 subparagraph 3. Sorry, I should have page numbers and I do apologize. Yeah, so we're on page 90. Council says, second line down at the end of it, he maintained a detailed cash ledger. But so the council saying he produced them. In cross-examination, he said somebody else produced them. That's day 8, page 184, lines 9 to 13. He said the accountant produced them, not him. So we don't even know where these come from. What we do know is that even on his documents, many of the uses we can see were not for the benefit of Health and Sites Dubai. So you've got quite a lot of payments going to Mr. Abulfadl and Mr. Saad, and they're said to be end of service gratuities. You can see that in the ledgers at E361. But those people were never employed by the second claimant, second defendant. They were never employed by Health and Sites Dubai. And surprise, surprise, these are people who now work for Mr. Shehata's company. So these are payments which he says are salary or end of service benefit gratuities, but these are people who've gone over to work for him. And clearly I mean, who knows where they worked for previously, but they did not work for the Health and Sites Dubai. So there is no proper justification for using Health and Sites Dubai for them. And then you've got reference to payments for translations, which were used in Mr. Shehata's own proceedings in Egypt, and for use in these proceedings. And indeed, some of the fees, for example, at K64, pages 2 and 3, you will see our fees for work done on these proceedings. So Mr. Shehata's own defence and counterclaim. So where we can see the actual use, it is not for Health and Sites Dubai. So where do you get to on that? He's admittedly taken company money. He's paid himself that money. He says, I didn't have any other option. Of course he did. He could have handed it over to the claimants, or he could have put it in the hands of the people, or he could have done something else. He's paid some of this to people who became his new employees, who were not employees of Health and Sites Dubai, and he's used it to pay his own personal expenses. And then he's produced a flurry of documents to try to cover it up, very much at the last minute. So this documentary support that was produced really came in right at the last minute before trial. And yet it is, there's strident criticism of counsel for suggesting that he's misappropriated funds. And paragraph 287, the claimants are accused of knowingly lying about this, knowing that he did it all perfectly above board, and nevertheless making assertions which are false. which is totally unwarranted. So should a director who has taken company money and used at least some of it for his own personal gain account for that money, is the question that Your Honour will be asked to answer. We say obviously yes. So those were my 10 minutes on that.
Just on that last point, Mr. Montague-Smith,
Yes.
In your written closing submissions at paragraph 420, you set out the relief that you're seeking. In subparagraph 7, in relation talking about the payments, you say an order pursuant to regulation 79.6 setting aside the payments, but that's not really the way you're putting it, is it? And indeed, let me go back a step. If I find that Mr. Shehata took the money out of the bank account and he has not, and I don't accept his explanations for it, there are no transactions to be set aside, are there? The way you've put the case is that he's simply taken the money and should account for it. But it's not a case of setting aside transactions under regulation 79.6, is it? It's just a case of, I think your words were, he's misappropriated the funds and there should be an order that he account for them.
I slightly disagree with that. It depends what you mean by transactions. So
well,
transactions,
if money is taken
just
for no consideration, that
Yeah.
can't be characterized as a transaction, can it? Sorry, it all depends on the context, of course.
Yeah.
And regulation 79.6 is all to do with where somebody has an interest in a transaction.
Yeah.
It's talking about contracts and other arrangements in which somebody has an interest in it, not simply misappropriating funds, is it?
Well, I think we would say that transaction means more than contracts, and I mean, obviously we're not dealing with DIFC law, but one of the points that does arise under, or used to arise under DIFC law, under the judicial authority law, was what constituted a transaction, and the Court of Appeal was quite content that meant more than just contracts. It's about legally. It's about how can I articulate what a transaction is? But in common parlance, one might say, how many transactions have there been on your bank account, and that would be a perfectly acceptable use of language. So in a common man's approach to it, and that would constitute a transaction affecting a payment out. And the question is, are you taking a step which results in legal consequences, if I can put it like that? And if the answer is you're in control of someone's bank account, and I'll ask the question: if is the regulation, say we were talking about a chattel, an expensive chattel, and he had transacted with himself to buy it for a penny, would then you're saying the regulation would apply, but not if he'd just transferred it to himself for no pennies, but he'd taken so if he's just got the chattel, then it's not a transaction because there's no legal consequence that's affected the ownership of that thing. That shows. But if he's actually taken steps to transfer the ownership, perhaps a chattel isn't the right example, then the fact that there's no consideration for it, I would suggest, is not what the mischief of the regulation is looking for. The mischief of the regulation is, has he appropriated something or taken an effect? Has he affected a legal change which has had legal implications on the company? That needs to be reversed in one way or another. Otherwise, you just get the stuff back. If you see what I mean.
Yes.
Does that answer your question?
Yes, I understand that.
Thank you. It's not a point that's taken against me, I should say. It's not a point that's raised against me. So Your Honour is ahead to that extent.
All right. Well, thank you.
Thank you.
I've delayed you a little more. Perhaps if we could adjourn until 2:10, that will give us about 37 minutes, I think, Is that enough for you, Mr. Doherty?
Yes, Your Honour, that's fine.
All right, so we'll resume at 2:10. Thank you.
Thank you.
Yes, I can see Mr. Doherty. Mr. Montague Smith, are you with us?
I am. Apologies. I
all right.
lost track of time.
It's all right. I'll just give you a moment to get organised.
Thank you. I think I'm as organised as I'm going to be. Thank you.
All right. Yes, Mr. Doherty.
Thank you, Your Honour. The topic that I'm going to address Your Honour on this afternoon, where you honoured out, is the issue of ownership of MCC by Health Insights Dubai. Obviously, you have our detailed written closings. Neither today nor next week I'm going to profess to cover every topic in that. It's set out in some detail in writing, particularly when it deals with factual submissions, which will have all of the references that we want Your Honour to rely on. What I'm going to focus on, particularly today, is to draw Your Honour's attention to what we say the state of the claimant's case is on the law when it comes to the development of MCC, and the state of the claimant's pleaded case on that issue, and I'm going to work through it in that order. If I can deal with the legal analysis first, curiously little has been said, either in written closing or just now in oral submissions, about how the law works in this area. And we said that's a pretty important oversight, given that this is a quite specialised area of law, which Your Honour is being asked to adjudicate, that is on questions of IP ownership, but particularly where what we're dealing with is references to principles of non-DIFC law. I am going to spend some time going through the legislative requirements and explaining to Your Honour why whatever framing of this case you take, including taking the claimant's case at its highest, they simply cannot get to a position where they can explain how Health Insights Dubai at any point in time came to acquire intellectual property rights in the MCC software. The case doesn't work. And before I get into the detail of that, I just want to make it clear what exactly it is that we're talking about. What is the IP here that Your Honour is being asked to adjudicate on? When you look at how the case is framed, the whole reason that this matter is an issue is because the claimants assert that Health Insights Dubai owned something which it is referred to as the MCC rights. They say that Mr. Shehata has assigned the MCC rights to another entity, Health Insights Malaysia, at an undervalue. And they say, for that reason, Your Honour should set aside the agreement which purports to do that, that's the assignment agreement, and require Mr. Shehata to account for that. Now, the IP we're talking about, what this case rests on, is what was described in the original Part 8 witness statement set out by the first claimant. That document, if you can pull it up so Your Honour can see, it's a D1, page 6. And if we scroll down, please, to 21, which is the paragraph referring to the assignment agreement. It says the first defendant purported to transfer the IP in exchange for $500,000, and the assignment agreement contained the key terms. And then it's clause 1.1, which defines the property rights, and what's being referred to there is specific IP rights. So author's design, MCC, user interface design, composite copyright work, work of drawing, brand, Medica Cloud Care, software program, Medica Cloud Care source code. And if we go further down, please, to paragraph 24 of the same statement, what's asserted as the intellectual property referred to in the assignment agreement is a software program known as MCC. which is a cloud-based hospital management information system that provides unified medical record. It is fundamental to the business of Health Insights Dubai. And if we go please to page 9, and subparagraph B, 28B, sorry, if you could scroll to, bear with me. Yeah, so right at the bottom of page 9, first of all, so the top of subparagraph B for paragraph 30. Yeah, right at the bottom. Keep going. So this is, secondly, the defendant purported to sell the IP rights for a price much lower than the value of the IP. And then it refers, of course, to the offer that was made with respect to the company. And over the page it says, whereas prospective purchaser is willing to pay the company 65 to 100 million dirhams, the first defendant purported to sell the IP rights for 500,000 only. So again, the property, the value that is said to have been transferred at an undervalue is the IP rights in MCC. It's the source code for MCC. That's the system that we're talking about. We're not talking about Medica Plus or source code written for a program that was created in the late 90s and early 2000s, which is now obsolete.
I'm sorry, you said source code. Was that deliberately trying to confine it in that Mr. Montague Smith said that the MCC software is wider than merely than source code? Were you deliberately trying to make it narrower?
Yes, and that's for a legal reason, which is when you analyze the legislation and what the legislation protects. And I'll go through the detail of this, but in effect, computer programs are treated in the same way that a literary work is created. What you're protecting is the words. The words in this instance for a computer program is the source code. And it includes the object code, which would be how you execute the source code. But what you're not protecting, and you can't protect under the law, is the idea of developing a cloud-based medical system. The law doesn't protect ideas, nor does it protect the market research that you might put into deciding what your system should look like. And again, I'm going to take you through the bits of the law that tell us that.
But it might extend to the workflows which are reflected in the whole software, the way the modules are put together, what they cover, not simply source code, as I say, without great technical knowledge. That's, as you say, different from the object code, and there's more to it than just the source code, isn't there?
Well, what is being transferred under the assignment agreement is the source code, the UI interface, the name, and so on. So that we have to be clear about what the IP we're talking about is, because that's what the focus of the claimant's claim is. That's the transaction which they're seeking to set aside. That's the transaction which they are saying was undervalued. And it's the claimants who are using the terms here. This is the whole of MCC. What we're saying is that their legal analysis to work, what they need to show is that Health Insights Dubai acquired the rights to the MCC source code, and that is what is protected by the copyright law. And if they can't make out that case, then the claim for setting aside the transaction doesn't really go anywhere.
The copyright law doesn't in terms refer simply to the source code, does it, or does it?
Well, yes, we say it does.
That's your gloss on it, isn't it?
Well, it's not my gloss. It's what is understood, including in I'll take you to the academic text dealing with it, and what is understood by that. So what in any event we're not talking about is, as I say, even if you were to include workflows, this is not work product from the late 90s and early 2000s. We're not talking about Medica Plus as a system. Factually,
Well,
Medica Plus and Medica Cloud.
but if it was the claimant's case, is that Medica Cloud Care is a version of, a derivative of Medicare Plus. Now, if that is correct, then the owner of Medicare Plus would be the owner of Medicare Cloud Care, would they not?
No, that's also incorrect. I mean, this is the real problem. No proper explanation legally has been provided by the claimants on their case. So even when it comes to derivative works, that's a defined term within the copyright law as well.
Yes.
And you can be an author of a derivative work. So if you take something that was there earlier and you use it to create something new, you are the author of the derivative work, insofar as you've created new components and you have innovated new components.
Well, that's the point, isn't it? You're in a sense assuming the conclusion by describing them as, I forget your words, were new something or other. But that's the point, isn't it? Whether it is just a version of the old works, a derivative of the old works, or whether it's a new version, something quite new.
Well, indeed, but I mean, if you're changing from one source code language to another, if you're moving from one technology to another, if you're moving from a system which is architecturally different to another, you cannot say, and I don't think that anyone meaningfully seeks to argue in this case, that Medica Plus is the same as Medica Cloud Care. Otherwise, all of this analysis, even on the claimant's case, that it took 2 years to process this complex piece of software, wouldn't make sense. And we wouldn't be talking about the MCC rights at all. We'd simply be arguing about who owned Medica Plus.
But that's
It's
the whole
implicit in the
point,
case.
isn't it? Where something is a derivative of another program, obviously that there are differences, there are changes. Otherwise, as I say, they would just simply be the same thing. But
Well,
there is
exactly.
there's a judgment to be made, isn't there? Whether the new second program, if you like, is a derivative of the first one, or if it's a new, independent, separate program. And that's a question of fact, isn't it?
No, because the problem for the claimants is that, and they must accept that Medica Plus is not the same as Medica Cloud Care. Medica Plus, as it existed in 2002, is not the same thing as Medica Cloud Care. So something has changed. We have different arguments and different ways that we put that to your honour, which I'm going to come and deal with anyway. But the point is that even if what you're asserting is the creation of a derivative work, the way in which the law treats the derivative work is that the innovative aspects, the things that have been created by taking the original thing and making it into something else, the IP rights for that innovative work vest in the author who's done that work. That's the default position under the law, whether you're creating something new or whether you're creating something derivative. So let's work through it as a hypothetical example. If you take a software program that existed in 2002, and I was to take it now, and say, well, whatever happened to that system that was useful, I could see a modern version of this adapted to a phone being really useful. And I develop that idea, and I take the derivation and I create something with it. The innovative changes that I've introduced, I have authored. So as a matter of the way that the intellectual property and the copyright laws the claimants are relying on work, would be to say that the rights that I have created, the rights that I have innovated, would vest in me. So whichever way you frame it, the problem that the claimants are always going to have to address is how is it that Health Insights Dubai, as a legal entity, came to acquire the IP rights. It's not enough to say that there was an assignment of rights back in 2002 and that's a thread that can just carry through in perpetuity. The law doesn't work in that way. So you have to have some analysis which gets you from A, the author who created the work owning the IP, to B, which is the legal entity owning the work. And the only way that you can do that is through this collective work analysis, which really is the...
Do you say that if the program is taken, which at the time operates on a separate laptops or whatever, and then that program is put onto a cloud base, that necessarily, that it must, as a matter of law, be a new innovation, and that as a matter of law, the copyright must subsist in the persons who wrote it to put that platform onto a cloud-based rather than a individual base? Do you say that as a matter of law that's so?
Yeah, to be clear, obviously that's a proposition we don't accept as a matter of fact. And Your Honour, of course, doesn't have any fact before you on the claimant's case which could make out that analysis. And this is part of the problem. The claimants haven't explained the legal analysis. And so the court is left having to guess at what are actually highly technical questions. For example, if one is trying to say, well, is medical client care derived from or slightly, materially, significantly based on code that was already written and produced as part of Medica Plus, what Your Honour would obviously expect to have before you is the source code and some form of technical analysis which compares the two. But because no case has been advanced that says that MCC is a derivative work, that's not the way that the case has progressed. And so you don't have any evidence of whether MCC source code was derived from Medica Plus at all.
I'm sorry, Mr. Stockley, I understood from Mr. Montague-Smith that is the way the case is put.
That's the way the case is put this morning. It's not the way the case has been put in pleadings or in evidence or, in fact, anywhere else. But be that as it may, if that was the case that they were advancing as a proposition of law, you still have to show, if what you're asserting is that this is a derived work, that you are either the author of the derived work, or if you're a legal entity, you have to show that you have acquired the rights to the IP in that derived work. And there are effectively two ways that you can do that as a legal entity. One is through an assignment, and the other is through this collective work analysis, which is really where the legal issue on which the claimant's case hinges. And what the claimants need to show is that the source code, which, as I've taken you to, is the protectable bit of IP, the material protected bit of IP that they are saying was transferred through the assignment agreement, they need to show that that source code was authored or developed in a particular way that led to its rights vesting in Health Insights Dubai. That is the only way that they can claim some form of protection under these statutory provisions they rely on. And just to take Your Honour through some of the detail of what the law says, we can turn up page 16, page 4. And I should say, for present purposes, I'm going to refer Your Honour to the 2002 copyright law of the UAE. It's another telling feature of this case. The claimants don't actually say which one of the three laws that they've entered actually applies. We deal with that law because it seems like the most probable or the most relevant, where they're claiming IP ownership from a process that occurred between 2016 and 2018 for an entity located in Dubai. But the explanation of what the other two laws do or why is unexplained. But if we open up these H16, this is the 2002 UAE copyright law. If we go to page 4, if you can scroll down, please. There we've got Article 2, which says that authors of the works and holders of the neighbouring rights will enjoy the protection of this law. And for present purposes, it's subparagraph 2, which refers to computer programs and applications, databases, and work analogous to them. So the author of the computer program is ordinarily, by default, the person who enjoys the protection of the law. As to what the computer program means, if we go from there to H 116, please, page 9. If it's possible to zoom out these slightly. Sorry, can we go to the top of page 9? Sorry, Anna, for some reason the top of that page 9 is different to mine. Is it possible to scroll down, please? If we keep going, go to the bottom of this document is where it's most likely to appear. I don't know why my page numbering is showing as being different. Scroll up. If it's possible to zoom out, please, and find the internal page number 201, if that's there. Sorry, bear with you, my honour. I have no idea why. The document I'm looking at is H116/9. There it is. Scroll into the top of the page that says source code and object code, please. It's done. Next page. There. And if you can zoom in, this refers to what's actually protected under this aspect of the law. So this is taken from an academic text, which is Intellectual Property Law of the UAE. It refers to the ARL's mention of computer programs and their applications. It says the TRIPS agreement refers to source and object codes. So this is an explanation then as what is the distinction between a computer program and its applications, source and object code. When a computer programmer writes a program, he or she is writing a source code in a programming language such as Virtual Basic. The source code cannot be read by a computer unless it's converted or compiled into an executable machine-readable program. That's the object code. When a consumer purchases computer software off the shelf, it's a copy of the executable object code that's being obtained. The source code is not directly available, but can be decompiled. The reference in the ARL to computer programs and their applications is presumably a reference to the source code and the object code, both in principle are to be protected as literary works. So that analysis is consistent with what is purportedly being transferred in the assignment agreement. And it frames the way that Your Honour has to view this case, which is who owns the source code to MCC? That's the question. Now, in general terms, as we've looked at, so that was at Article 2 of the copyright law, the law protects authors of works. So authors in that context are the natural persons who create the work. So the default position as a matter of law is that if you author a work, you acquire first ownership rights to it. Under Section 5 of the copyright law, there are exceptions to the normal rule. And we can see those if we go, please, to H16 at page 11. Which is Section 5 of the law, deals with special provisions on some works, and the relevant part is Article 26.
So can you just remind me, what law are we looking at?
This is the 2002 copyright intellectual property law for the United Arab Emirates. Yeah, so if we scroll, we can scroll to the top. It's Federal Law 7 of year 2002 concerning copyrights and neighbouring rights.
Right. Because I'm looking at, it's got at the top, collection of laws for electronic access. Is that just some description of that part of the law, is it?
Yes, I think this is taken from the WIPA website. So that's a website where you'll get a number of versions of different countries' laws. So I think that the version of the Egyptian law, for example, is taken from the same source.
All right.
And this is, I think this is part of this is the law that the claimants cite in their closing, which they refer to. So it's their reference, and I don't think that there's any objection that this is the correct reference.
IP law, okay.
Yeah, and this is the law from 2002. There was another law which replaced it in 2021, but given that what we're dealing with is a dispute about who developed what in the mid-2010s, we refer to this law as being the one that's most likely to be relevant for your honour's analysis. So under Section 5, scroll down please to Article 26. Where the default position is an author, a natural person, owns any rights in something that they have created. This creates an exception which enables, in some circumstances, a legal person, so in this case a company, to acquire those intellectual property rights, provided that a number of criteria are satisfied. So what Article 26 says is that the natural or legal person who has directed creation of the collective work can practice alone the author's economic and literary rights, unless there is an agreement otherwise. So that's the exceptional mechanism which we say the claimants have to assert applies in order for Health Insights to buy as a legal entity to acquire ownership of MCC and to acquire ownership of the MCC source code. And that is what is asserted in closing. Is what Your Honour was told on the first day of trial was going to be the case that the claimants advanced. And the claimants haven't explained, either in written closing or in all submissions, how this law really applies. And when you work through it, you can see that it doesn't. So the definition of collective work, if we scroll up in this same document to page 3, the bottom of the page, says that collective work is a work compiled by a group of authors under the direction of a natural or legal person who pledges to publish it in his name and under his own supervision. The contribution of authors will be assimilated into the public goal aimed by such a person in such a way that separation and distinction of each author's contribution becomes impossible. Now, one has to actually grapple with the different requirements that are set out there. If one looks at what is required of a collective work, broadly you can extract 6 different steps that you need to go through. So 6 requirements which are embedded within those legislative provisions we've just looked at, which the claimants need to prove, we say, in order to assert that Medica Cloud Care was owned by Health Insights Dubai on the basis that it was a collective work. Those are, first of all, that the work has to be created by a group of authors. So what that means is that you've got a collection of natural persons who are undertaking the creative work involved. The second is that the group of authors must work under the direction of a natural or legal person. So you've got a requirement for the person who is ultimately going to acquire the IP that they have directed it. The third, which is I suppose a sub-point within that, is that the person directing the work must actually direct its creativity. The fourth is that the contributions of individual authors must be incorporated into the work for a purpose that was intended by the director. The fifth is that the director must have pledged to publish the work in its name and under its supervision. And then the sixth is that it must be impossible to separate or distinguish the works of the individual authors. And I'm going to come back to breaking that down in due course as it applies to the claimant's case. But if I can take your honour through some of the finer points of detail around how this law is intended to apply. And the first point really is about the need for creative input. So when one is actually looking at what this copyright law is intending to protect or to grant people protection over, is the work they've contributed as part of an involvement in a creative process. So for example, if we go back to page 2 of this document, one can see in respect of authors, there's, if you scroll up please, one of the first definitions is of work, which is any created compilation in the scope of letters, arts, sciences, etc. And scrolling down slightly to creation, creation means the creativeness which gives genuineness and distinctiveness to the work. So when the legislation has a requirement that someone creates something, what it is requiring is some active involvement in creation, in the creative process, in the creativeness as it's defined, that gives genuineness and distinctiveness to the work. And we say that's clear from some of the cases that you see in this area. And one of the examples I've given, which was added as a further authority in the bundle, is case 288 of 2012 of the Dubai Court of Cassation. That document is at H118, page 2. And if we scroll down to the bottom of page 2, please, it's the final paragraph where there's a discussion about what Articles 1, 2, and 3 are concerned with. And it's the final sentence here, which is intellectual work, means any creative product in the field of letters, arts, science, of whatever type, expression, method, significance, or purpose. In accordance with this law, innovation means an innovative attribute grants the work a sense of authenticity and distinctiveness in terms of its preparation, realization, formulation, coordination, and preparation for bringing it into existence through publication or copying, whatever the means of doing so are. So the point of principle we asked Your Honour to extract from that is that creation or innovation, in order to be protected by the law, requires there to be some involvement in the preparation, realization, formulation, coordination, and so on of the work that's being created. But differently, you can't just have a passive role in the creation of something. In a relatively common context, if a musician or a band writes a song, they author that piece of music, and it doesn't matter if someone else has asked them to write it or if someone else has funded their time in the studio. The fact that a record label foots the bill, assuming they haven't introduced some contractual mechanism which would let them acquire the rights, doesn't make them the composer of the song. An 18th century composer's patron wasn't the person who composed the works. That's obvious. But that analysis is equally relevant when one comes on to look at the role of a director for a collective work. And we'll come to the legislative provisions for that in a moment. But if we can go back to the academic text that I referred Your Honour to at H116. And if we go, please, to page 10 and then zoom out slightly. Zoom out and go to the top of the page, please. So this is setting out the concept of work is at the heart of the law itself. If we scroll down, please, under the section creative work, what that says is that the law protects works that are creative. And that gets into the detail of what the Arabic words used in the legislation are. And it says a literal translation of this would render it as created. However, in English, almost anything can be created. It's a word closely synonymous with made, but the Arabic word used imparts a stronger sense of creativity, having been employed to produce the work. So what that underscores, again, is what the legislative intention is to protect the creative process. It's not to protect what people might consider to be commercially desirable outcomes. The clear problem we say that arises for the claimants is when you actually tackle the law head on in this area, there's a real problem for the claimants and how this applies to the directors of collective works. And I've already showed you Article 26. But what Article 26 says is that the natural or legal person who has directed creation of the collective work can exercise the rights of the author. And those words are, we say, extremely important. They have to direct creation. Authors can only be natural persons. The effect of Article 26 isn't to make a company an author. What it does is it entitles a company in certain circumstances to assume rights that would ordinarily pass to an author. But for the legislation to bite in that way, the director has to direct creation of the work. And what that necessitates is some creative input from that legal person, which, when you apply it to a factual case, is an extremely difficult analysis to run if you're a company. And this is set out if we go to page 3 of this text. which explains the problem quite succinctly. And under the section Authors, which deals with this question of natural and legal persons at the bottom of the page, it says an author is referred to as a person without qualification. From the point of view of everyday experience and common sense, authors are always natural persons. The ARL gives some special attributes to legal persons, and a legal person has, according to the law, the ability to direct creation of a collective work. And it observes, quite rightly, that in the circumstances in which this might be possible are difficult to imagine, because legal persons usually have no ability to direct, other than as a result of decisions and actions of natural persons who are themselves potential authors of directed works. And really, that's just making the point that where there is a requirement to direct creation, and where companies in reality have to act through authorized officers and agents, you have a pretty tall order in explaining how it is that a company could come to acquire the first ownership rights over a piece of intellectual property on the application of this law. And if I can deal with this in some more detail, if we skip forward, please, in the same document to page 8, which is a section dealing with authors of collective works. And there, this sets out what I've already suggested to Your Honour, the criteria that you have to apply. You'll see that there are 5 from A to E, and then the 6th begins at the paragraph after E, which says, Article 26 of the ARL appears to introduce a further criterion, that the natural or legal person directing the work is to have directed the creation or creativity of it. If the criteria for the existence of a collective work are satisfied, the director alone may exercise the financial and moral rights. What it then poses is the problem, which is the director, whilst it may be a legal person, is problematic. Legal persons like companies act through their employees or representatives, and a company as an entity couldn't, except through the efforts of human beings, direct the creativity of works. Now, there are, of course, workarounds where you're a company which is faced with that problem. And if we go over the page, for example, one could refer to, if you're a company you're faced with this scenario, is an obvious fix would be that you put in place arrangements by which either employees or agents that you've got working for you agree that any IP that they create during the course of their work will be assigned to you. That's one way that you can acquire the rights in works carried out by natural authors.
Is that necessary, or is it not the law that if an employee creates a work in the course of their employment, then the copyright belongs to the employer unless there is some different agreement?
There are statutory frameworks which include provisions like that. This one doesn't. I think, but I need to go back to it. I think that the DIFC's intellectual property law does include provisions like that. And I think, for what it's worth, the DIFC's intellectual property law sets out a different set of criteria for when a collective work can be created. And for that matter, I think that the 2021 intellectual property law might include some provisions which changes the laws a matter of onshore federal law, and suggests that a default position would be that if you're an employee and you create a piece of IP, that the company is assumed to own it. The relevant point for present purposes is that there's no such provision in this law or the law that applies in this case.
Why do you say the UAE law applies?
Well, I think it's for the claimants to explain the basis on which they say this law applies in order to give them IP rights. The reason we say it's the most likely to apply is because, one, this is what the federal law that was in force at the relevant time of this dispute was. So at the time, both parties assert that that MCC was created, this is the law that was in force. So that's
the
the
UAE.
first point. In the UAE,
What-
correct.
What if the creative work was done by employees of HI Egypt in Egypt?
Well, this is a
That-
material problem for the claimants. We would make the point that what they have said is, well, look, here are three laws. They all apply the same. It doesn't really matter. I'm not sure that that's correct. Your Honour, if you're going to make a finding on this, going to have to decide which law applies. One of the things that's been introduced by the claimant's case as advanced at trial, which didn't exist in the case it advanced up to and including the witness statements, was the suggestion that some of this work was carried out by employees in Saudi Arabia. And in fact, the whole idea began in Saudi Arabia. That's where the work started. But there's no reference in anything the claimants have said to what the law is in Saudi Arabia, which is a pretty glaring oversight.
If I can just go back to the proposition I was asking about before, if it was the case that the creative work was done in Egypt, would it be the law of Egypt that determined ownership?
I think for present purposes, what's being suggested is, I think the critical factor in identifying the UAE law is that the case as asserted is that Health Insights Dubai, based in the UAE, acquires first ownership as a consequence of its involvement in the direction of the process. So in that respect, we would say that the first ownership arises as a matter of UAE law.
Well, does it, if the, again, I ask you, if the actual creative work is being done by workers in Egypt, and add probably the extra element you put in, if the director, well, we'll take both examples. If the work is being done in Egypt and the director is physically in Egypt, then would the relevant law be the law of Egypt?
I think that must be right. I mean, really, this is the difficulty, though, in the way that the claimants have pursued
Right,
this case.
Can I put another one? The other example that I think you said, if the workers, and perhaps on your analysis, the people writing the code, if they're in Egypt and the director is in Dubai, then which law applies?
Yeah, so if what you're being asked to conclude is, did Health Insights Dubai direct the creation of this work and therefore assume IP rights, that ownership would arise, given that the company is situated in the UAE, in my submission as a matter of UAE law. Now, that has to be the way that the claimants have framed its case. So that is that really is a question for Your Honour.
I'm trying to get from you. If well, let's take another. I can't remember where the evidence is about where Mr. Shehata was physically located, but if the position was that Mr. Shehata was the director and was an employee of HI Dubai, but he was in Egypt and the people writing the code were in Egypt, wouldn't the relevant law be the law of Egypt, on the basis of that's where geographically that's where the work is being done?
I think probably the more relevant question in that circumstance isn't where the underlying work is being authored, it's where the direction of the work is coming from. Because in this analysis, it's not the location of Mr. Shehata, it's the location of the legal entity that's directing the work.
But you've told me that there has to be a natural person. The director is a natural person. And
no,
isn't that right?
The director of the work as a matter of law can be a legal person. The factual circumstances which would get you to a legal person being the director of a work in that way, we say is extremely narrow. And that's the difficulty that the claimants have to overcome, because they would
I'm
need
trying to
to
get this
explain.
conceptually, if you can help me with this. Supposing there is a US company and its employee is situated in Hong Kong, and both the director and all the coders live in Hong Kong, never go near the United States. Which is the relevant law then?
I'm not sure I could answer that, Your Honour.
Well, I've thought consistently with what you've been telling me before, it's where the work is being created and directed from. And the directing from means where the director is. Is that not the way you've been putting it to me?
Well, no, the way I, and again, let me be really clear about this, because this is the case that is being advanced by the claimants, and the way that they have chosen to advance it is to say one of three laws potentially applies to this case. They still haven't told Your Honour which one they say is the law that applies. So what the defendants are doing is trying to adopt and deal with what seems like the more likely law that applies. And I've given you the reasons why, in circumstances where it's said that Health Insights Dubai, which is a onshore Dubai company, directed creation of this work. I've given you the reasons why we say that probably the law that applies to a case put like that would be the 2002 federal law. Now, if one was to go and look at a potential counterfactual, and let's say you did say that the Egyptian law applied, the requirements in that law when it comes to the creation of collective work are materially the same. That's not to say that the onus still isn't in the claimants to identify which law actually applies, but the hurdles that they would need to overcome are the same.
Except I thought you told me that a distinction is that under the Egyptian law, there's a provision to the effect that a work created by an employee in the course of their employment belongs to the employer.
No,
So
that's not my understanding. No, not with the Egyptian law. Not to my knowledge or understanding.
Okay.
I'm sure that if I'm wrong about that, someone will correct me. But in any event, there's no case advanced that IP ownership arose through the employment status of the individuals who were working on it. That's not the case the claimants are putting, and so it's not the case that I've been asked to meet. I'm trying as best I can to meet the case that I think is being put, albeit not actually explained at any point. The point I was making is that if faced with the difficulties that are inherent in this statutory framework, you as a company want to put in place protective measures when it comes to your IP, what you can do is you can insert clauses into your employment contracts, or you can insert clauses into contracts that you engage consultants to deal with, addressing the question of IP ownership, which would say that you, in effect, undertake to assign to us any rights and things that you have produced during the course of your employment or whatever it happens to be. So that's a contractual workaround to what is otherwise a pretty difficult test to meet. And really that's the point that's being made at the top of this page, that's at the top of page 9 of the document we've got open. Where it says that the legal person who's directing the work in the first instance is likely to be the owner of the rights in the collective work, rather than it being the legal person itself. And a separate set of arrangements will need to be made to transfer the director's rights in the collective work to the legal person. And so, in effect, what you're doing is just kicking the can down the road the way the legislative provisions work, which is that one might put in place a set of contractual arrangements where you've got, say, someone employed as the creative director of a business, and the creative director tells the employees what to do. And from the company's perspective, in order to protect your IP rights, you enter into an agreement with the creative director saying that anything produced under your direction is owned by us. That's how you can acquire the rights.
Might you also acquire it if the director, in the sense of the director of the work, is a director of the company? Then the director may, if the rights go to the director may hold those on trust for the company.
Possibly. It's possible that one effect of the way this law works is that if you are a director who has the authority of the company and that you make out all of the other requirements because the company is acting through you, that either there would be a direct acquisition of ownership by the company, or, as you say, depending on the legal framework that they exist in, the company could hold that property on trust. That is possible. But on the analysis that one has to go through in this case, it can't work. And I'm going to come to that and how you apply the legislative provisions to the facts. But if we look to the next paragraph, so I've referred you to the top paragraph, which refers to the workaround. What it says is that the nature of the direction exerted is important. It must be direction of the creation or creativity of the work. This suggests that more is required than providing the conditions to do the work and giving a general instruction to create the work. The direction, it seems, must be such that it affects what is creative or distinctive about the work. In this sense, the direction need not be in relation to every detail, but should be over those matters that are part of the creative effort. So, again, coming to the scenario that Your Honour was postulating, if you've got somebody who's a director of a company and they instruct employees to carry out a particular type of work, and that in theory is something which could, given if the circumstances were right, lead to the creation of a collective work, what you also need is not just an instruction, but creative input. So it's not enough to say, you do this, or you go away and create this thing, and then have no further involvement. There is a much more involved and less passive involvement you've got to have. Nor from the company's perspective is it enough to say that one of our authorised agents instructed a team to carry out the work, but ultimately, and also paid for the work, which was created. So there's nothing here that says footing the bill is a precondition to you directing the work. As I say, that the important thing is involvement in the creative process, not in the commercial background or the funding or whatever it was that sustained that process. So even if there was evidence, which doesn't exist in this case, that somebody at Health Insights Dubai issued an instruction to various different individuals, we'll come to them in due course, but on the claimant's case from Health Insights Egypt and Al Khalij, and asked them to commence work on the development of MCC, that isn't enough for it to be a collective work. And then at the bottom of this page, the final paragraph, beginning with another, refers to a further limiting factor, which makes clear that the case that the claimants have to make out is an extremely difficult one, which is a limiting criterion is the requirement for the contributions of the authors to be inseparable or indistinguishable. Many works produced by groups of authors preserve the contributions of each, especially works produced in office environments. Reports, advice, and analyses are often prepared by several authors, each contributing a section or part. And again, I'm going to come on to apply that to the facts. But if I can apply the principles we've just looked at to the claimant's case, it falls apart remarkably quickly. So, first point, on the claimant's case, the individual programmers or developers, however you want to put it, they didn't work under the direction of Health Insights Dubai. And the first point is that on the claimant's case, there is no way that Health Insights Dubai could be said to have directed the work. So there's no evidence of an instruction being issued on behalf of Health Insights Dubai as a legal entity. instructing others to engage in any development work relating to MCC. So there can be no basis for establishing that anyone, whether it's Mr. Shehata or a group of employees from Health Insights Egypt or anywhere else, developed MCC at the direction of Health Insights Dubai. And again, the factual premise of all of this is, of course, disputed, and you have my written closings on this. But even if you take the claimant's factual case at face value, the individual authors, they assert, were responsible for developing MCC in 2016 or in 2017, can be said to have been working under the direction of Health Insights Dubai. So in paragraph 30 of C1's third witness statement, what he says is MCC could not have been authored by Health Insights Dubai, the only company who had the capability to develop sophisticated and complex software was Health Insights Egypt. And the first claimant's evidence under cross-examination referred to the fact that Health Insights Dubai had only 4 or 5 employees. You might recall that was in his discussion about what he thought was the mother company. And the way that the claimant's express case is put on closing, I quote this is paragraph 181 of the Learned Friend submissions. Mr. Shehata did not work on the development of MCC. That
which paragraph?
That's paragraph 181. That proposition, we say, is fatal to the claimant's case on ownership, vesting, and Health Insights Dubai. Self-evidently, for reasons I've taken your honour to, a company can only act through its human agents. Mr. Shehata was Health Insights Dubai's general manager. If there was anyone who was authorised to issue an instruction or direction on behalf of Health Insights Dubai, it would have been him. So if the claimant's case is that Mr. Shehata wasn't involved in the development, how can they possibly assert that Health Insights Dubai directed the creation of a collective work? The claimant's express case seeks to fully exclude Mr. Shehata from the process and from any involvement in the development of MCC. And what that does is it renders their legal case incoherent. It's also worth reminding Your Honour, still within that context, that the claimant's factual case now, if not before, is that the origins of MCC lay in Saudi Arabia. And that's where they say the work first started. And that is impossible to reconcile with the assertion that, in a matter of law, the creation of MCC was directed by Health Insights Dubai. So the case fails because there's no evidence on there being any direction from Health Insights Dubai. But even let's assume that there was an instruction that went out there sent by, let's say it was sent by Mr. Shehata to a group of employees at Health Insights Egypt saying, please work on developing a cloud-based version of this system. And then Mr. Shehata ducks off to Germany for a period of time. If that was what the claimant's analysis was, and at least part of that seems to be their factual case, that analysis doesn't work. It's not enough, as I've said, to just issue an instruction or for the funding to emanate from Health Insights Dubai. That doesn't make you the director of a collective work. And that's because the statutory requirement is that you have to direct creation of the work. And creation is a term which carries a meaning within the legislative provisions. So that's the first point. But of the 6 requirements I gave you, another was that the contributions of the authors that are incorporated into the work needs to be for the purpose intended by the author. Now, again, there's no evidence of what Health Insights Dubai as a legal entity said or instructed to be the intended purpose of any individual author's contribution to MCC. And if that intention existed, it probably would have needed to have been expressed by Mr. Shehata, who, as I say, the claims assert wasn't involved. But it's potentially an even bigger problem when it comes to this idea of directing any creative element of MCC, because there's no evidence to support the legal entity Health Insights Dubai directing the creation, and in fact, that suggestion would contradict the case put forward by the claimants on the facts. So, on their factual case, it was an individual, and this appears to be the positive factual case, an individual at the end of 2016 named Thamer Farhan was the person responsible for coordinating work carried out on this multi-tenancy single instance project. So this is the creative process that the claimants rely on, this window between 2016 and 2018, although their dates and evidence moved around quite a bit. But if he directed that work, he wasn't an employee of Health Insights Dubai. He was located initially in Saudi Arabia. So if the claimants were correct about the origins of this creative process, it couldn't make Health Insights Dubai the creator or the director of this collective work. Another theory that was postulated, again, this was the first time during Cross, is that there's this other individual, engineer Mohammed Mustafa, who directed the development of MCC. What Mr. Al-Shinawi said about him is he designed the entire design of MCC. That was day 5, page 171, line 22. And if that was correct, and if Your Honour accepted that, that would also serve to torpedo the claimant's case on the law, because he also was not employed by Health Insights Dubai. And just to get into a bit more of the nuts and bolts about what Your Honour would have to see in order to make out this case, I've referred to a case from the UAE Federal Supreme Court. That's at H117. And if you go, please, within this document to the bottom of page 8, the context of this case is the petitioner was asserting that it owned certain cartoon characters, which it says were created as a collective work by a number of employees, and that was for the purpose of them using in some cartoons dealing with environmental awareness. The respondent is an individual who, in effect, says that she created the character and she registered the character as claiming to be the author. And the points of principle at the bottom of page 8, and this is dealing with the question of has the petitioner demonstrated that this work was a collective work? So 4 lines up, among the characteristics of this type of work is that the contribution of the participants falls within the general goal intended by the natural or legal person, and it's not possible to separate and distinguish the work of each participant. The principal rule is that if the person who directs the creation, and then in brackets it says, brackets it says development and authorship of the work may alone exercise the moral and financial copyrights. And at page 9, it continues. This is 6 lines down, halfway across the line, beginning the records of the case are devoid of any indication that the petitioner made a decision, order, or regulation to form a committee or nominate specific members by their capabilities or identities, directing them to create, brackets, innovate, environmental cartoon characters for the purpose of using them in an environmental awareness, or that the petitioner distributed the roles and tasks to each one of them, or that it served the stages of work through the creation of those characters, considering that making the decisions, distributing roles and tasks, and supervising the stages of work completion are among the elements of direction under Article 1 of the aforementioned law for the work to be deemed collective. And based on that, an element of the legal definition of collective work is absent, which renders the work in dispute set forth by the regulator for a collective work. And then if we go over the page to page 11, at the top of the page, it says it's not sufficient to confer the attribute of a collective work merely because the petitioner actually used the characters for its awareness purposes. That doesn't mean it was created under its direction. So breaking that down, the fact that an entity has used the work doesn't mean it's been created under its direction. For a court to establish that something has been created under the direction of a legal entity, you'd expect evidence of the entity making a decision about its creation, actually nominating people to do the work, directing those individuals to create the work for a particular objective or purpose, that the director would distribute roles and tasks to each individual contributor, that it would supervise stages of the work. Those are the elements of direction that you require in order for something to be deemed a collective work. And there's no relevant evidence of any of that here. The third point I make relates to one of the other criteria that needs to be satisfied, which is that there has to be some pledge or undertaking by Health Insights Dubai that it was going to publish MCC in its name and under its supervision. That's what the legislation requires where something's being compiled by a group of authors. And what the claimants repeatedly assert in closing is, well, MCC was developed for the benefit of Health Insights Dubai. It was intended that it be owned by Health Insights Dubai. That's not actually based on any evidence, and in fact seems to run contrary to the claimant's case on the counterclaim, which is, as far as they're concerned, it seems to be Health Insights Egypt or possibly Health Insights Saudi Arabia who are actually entitled to benefit from the licensing of MCC. But in any event, it's immaterial. What the statutory provisions actually require is that there is a pledge. And what that means, the way you should interpret those words, is that there has to be some prior agreement before the work is actually created, that when it's finished, it's going to be published by the director. And if there's any other interpretation, what you'd end up creating is a scenario in which individual authors might be working under some misapprehension or misunderstanding as to how the IP in their work was going to end up being owned. And that doesn't seem to be consistent with the legislative intent. And there's no evidence anywhere of some expressed arrangement or intention that Health Insights Dubai was going to publish the work. In fact, the very fact that the rights weren't registered in this window of time between 2016 and 2018 somewhat leads to the conclusion that that pledge never existed. There's no evidence of steps or even preparatory steps being taken in around 2016 or 2017. And in fact, we say documents created at this time, including the licensing agreement, evidence a contrary intention. The fourth point, and this is another critical problem that the claimants face, is demonstrating that the contributions of authors can't be separated or distinguished. Now, that presents a very substantial evidential hurdle for the claimants. It is not sufficient for them to say that separation is cumbersome or difficult. It is not sufficient for them to assert that the application of the law leads to some unintended or inconvenient commercial outcome by segregating ownership amongst authors. What the court has to ask is separation and distinction of each author's contribution impossible? That is the standard that has to be applied. And if it isn't, then segregation of the IP would be the only possible consequence of the claimant's analysis of the case. What the claimants need to show you is that each component of the work is impossible, and that is extremely difficult, if not, as it were, impossible, given the way the parties frame their case. So Mr. Shehata's case is that MCC is a software program which is customizable by design. That's the whole point of the system, is that you can adapt it to fit the needs of an end user without having to go back to the drawing board and rewrite code from scratch every time you want to create something new. What you have is core components and tools which can be used to implement a system in accordance with the client's needs. So on that analysis, the core components can clearly be distinguished and separated from the end product that is created. So end user screens or modules that are designed for a particular hospital, for example. So the impossibility of separating out those components can't apply, we say, on the defendant's case. But dealing with it from the perspective of the claimant's case, whilst it's different, the factual analysis that's put forward is also fatal to the legal analysis that the claimants need to make out. Because the claimants expressly assert, and this is paragraph 188 of my learned friend's closing, what they say is there is no separate piece of software that is separate from the modules of MCC. MCC is described as a modular system. There are no core components. If you take the modules away, you've got nothing left. That poses a pretty insurmountable problem when you look at their factual case on how these modules were developed. And the factual analysis in this is set out from paragraph 177 of my learned friend's closing. But what they're saying is individual software developers are handed different functions and different assignments and different modules. The progress spreadsheets that they rely on show individuals taking a particular module and function, they say, and developing its coding into what becomes MCC. What the claimants say is each completed the progress sheet with the information showing their progress and converting from M+ to MCC the modules and functions for which they were responsible. And taking that at face value, the way that MCC was developed on the claimant's factual case is that you have a series of employees spread across Health Insights Egypt and Alkaleej, and it appears they're independent contractors too. They're assigned individual modules. Those are developed. Mr. El-Shinawi, for example, says, I did report engine and referral system and queue system. Mr. El-Shami says he did stores definition, store transactions, and so on. On that analysis, it's clearly possible to separate out the work of each contributor. And if that's right, and it is not impossible to separate out those modules, then MCC cannot be a collective work. And that's just as a matter of taking the claimant's case as asserted and applying the legislative provisions to it. The broader problem that Your Honour is faced with is that actually
I'm sorry,
carrying on.
just thinking back on what you said a minute ago, did you say if the modules can't be separated, then it can't be a collective work? I misunderstand what you said.
It can only be a collective work if it is impossible to segregate the contributions of individual authors on the claimant's analysis. So if it's possible that you can look at work carried out by each individual on the claimant's analysis and say that that individual did that piece of work, it runs through any analysis that this could be a collective work. Because if it's possible to differentiate what they've created with what someone else has created, then it cannot ever be a collective work.
So are you saying that if the modules are separate pieces of work, then you can differentiate them?
Yes.
But that presupposes then that the modules each module is a separate piece of work.
Yes, well, it presupposes that, which was the point I was going to come to, because it's the claimant's assertion that MCC is modular and that the modules were developed in this way, shown in the progress spreadsheets. So what I'm saying is if you take that case and you logically apply it to the provisions of law, it doesn't work. The broader problem, for Your Honour, which is something we'll come back to in due course, is you don't have any of the technical evidence. So they say they developed these modules and they've given you a progress spreadsheet. They don't give you the work product. They don't show you what development work they actually did. They don't show you what code they've written. You haven't been provided with a single line of code, the claimants say, that the four additional witnesses wrote. So just as a matter of fact, Your Honour doesn't have the means to determine the question of whether it is as high, this is clearly a high evidential threshold that the claimants need to meet. They need to show impossibility of separation. And where Your Honour hasn't actually been provided with what the work product is, or what the source code is, or any technical analysis around what it is that the claimants say was developed, that is an impossible question for you to answer. So you cannot make a positive finding based on this evidence that it is impossible to separate out the various different modules the claimants say was developed. And if you can't make that finding, then you cannot make the finding which is contingent, which the claimants need you to in order for the IP rights to vest in Health Insights Dubai. And really, that's the end of it. This is the only way that the claimants can get to ownership of MCC by Health Insights Dubai. They haven't grappled at all with the legislative provisions. They've ducked the question of the law. They've been ducking it since day one. And the case is about as unclear now as it ever was. There's been no proper explanation. But having been taken through a proper legal analysis, what we would invite Your Honour to conclude is that you cannot be satisfied that there is a legal mechanism through which Health Insights Dubai acquired the MCC rights. There is, just moving past this collective work point, a throwaway point made in closing submissions. So this is it's a single sentence in passing at paragraph 252, which says that in the alternative, MCC was transferred from Health Insights Egypt to D2, to Health Insights Dubai. That's not pleaded. It's not even advanced genuinely in the submissions. But there are obviously pretty significant problems with that formulation of the case. So as I said, it's not pleading. No one has explained when this contract transferring the rights was entered into, who entered into it, what are the terms. It's pretty surprising that that slipped in there. Second, there is no evidence at all before the court to support the existence of any agreement transferring IP rights from Health Insights Egypt to Health Insights Dubai. Third, Your Honour would be faced with exactly the same problems I've identified already, which is you would need to get to a point where Health Insights Egypt has acquired the IP, and you can't get there because the same problems with having to establish that it was a collective work apply, and there is no evidence which you can use to establish that Health Insights Egypt was the director of a collective work. The fourth point is that there are also express legal requirements for the assignment of rights under the copyright law. So if you go to H16, page 6, that's bundle H, tab 16. So this is back to the copyright law. And then, page 6, Article 9. Says that the author or his successors can transfer to a natural or legal third party all or part of his economic rights stipulated in this law, provided that it's in writing specifying the object of the right to be exploited, along with the purpose, duration, and place of exploitation. The author is the owner of all rights except what are disposed of openly. So those are formal requirements for there to be a disposition. You've got to have a contract in writing. You have to be specific about the object of what is being transferred and its duration and place of exploitation. And if you don't do that, or there's any ambiguity, the assumption under the law is that the ownership rights reside with the author. And this comes back to the point I made at the outset, Your Honour. It's not possible to look at the assignment of Medica Plus in 2002 and draw a thread that carries forward in that. You can't just say that because it's undisputed that Health Insights Dubai owned Medica Plus, that it will mean forevermore any future work, future development, future brand new software would automatically come to be owned by the company. The company still has to establish a legally valid route for the acquisition of ownership in circumstances where it is a legal person and not a natural person. And the ways that you can do that are, one, it's a collective work, in which case the first ownership rights reside in you as a legal person. That's one way, and I've taken you through that. And the only other way then is if there is an assignment, in which case you're not the first owner of the IP, you subsequently become an owner. But for that to occur, you need to have express contractual arrangements in place with the author.
But you're there excluding the possibility that MCC is a derivative work from Medicare Plus. You've put that to one side, I assume.
No, I'm not putting it to one side. What I'm saying is that even that analysis factually is wrong. The reasons we say that is, one, the scope of what the copyright law is protecting is the source code. Well, that's what's meant by computer programs. So what is being protected as MCC here is the MCC source code. And that also happens, as a matter of fact, to be the rights that we're actually dealing with, that were assigned under the assignment agreement. So no one here is talking about there's no allegation that Mr. Shehata assigned all of the intellectual property rights in Medica Plus. That's not an allegation. They're not saying that every single piece of IP, including Medica Plus, was transferred to Health Insights Malaysia. What they are saying is that MCC specifically was transferred to Health Insights Malaysia. And what that means for present purposes is the source code. And there's no allegation that the MCC source code is the same as the Medica Plus source code. So in terms of what can be protected across both of those systems is completely different. That's the first point. And the second point is that even if one was to follow through an analysis of there being a derivative work, which is wrong for the reasons I've already given, Your Honour, but even if you follow through that analysis, where you have a derivative work, it is protected in the same way as all the other enumerated types of work set out at Article 2 of the law. And what that means is that the person who acquires the rights in any derivative piece of work is the author. And the author can only be a natural person. And the only way that you can get around that is by saying that the derivative work itself is a collective work. Or that someone has created a derivative work and assigned it to you. So you still have to go through the same process of analysis. You still need to look at what is the work product that was created that is MCC, who created it, and were the circumstances of its development and creation such that either the IP vests in the company because it's a collective work, and if not, the only other way you can get there is through an assignment. There's no other way. And so when you actually look at the detail of the law, you just can't get there. The points that are enumerated in the claimant's submissions do not tackle this question head on. I mean, just dealing with them briefly, this is from paragraph 252 onwards. First, 253 says that it's not disputed that D2 owned Medica Plus. One, that's not really relevant. The only real relevance that you could extract from that, Your Honour, is effectively what my learned friend says, which is it's historic and it might give you some insight into how it was intended that MCC should be owned in due course, but that intention is not relevant to the statutory provisions which you have to apply in deciding whether or not a collective work was created. Also, just as a matter of fact, I mean, it might well be the claimant's lawyer's position. C1 says he thinks Medica Plus is owned by Health Insights Egypt. C1 also says that MCC is owned by both Health Insights Dubai and Health Insights Egypt. The second claimant refused to answer this question 9 times about who owned Medica Plus. And he also said expressly in cross-examination that MCC is owned by Health Insights Egypt. And in a separate question, he said that it is not owned by Health Insights Dubai. You take that for what it's worth. But as I say, it doesn't take us anywhere. They're different systems. It's not suggested that the ownership of Medica Plus was acquired because it was a collective work directed by Health Insights Dubai. Health Insights Dubai didn't exist when the software was developed. It acquired it later by way of an assignment. And there's no genuine suggestion, we say, that Medica Plus is the same piece of IP as Medica Cloud Care. And if that was going to be asserted, I would have expected the claimants to have asserted that directly, in effect to say that these are the same systems, it's the same piece of IP. Because if that is what was being argued, the court would have needed, in order to dispose of this case, to actually analyse the differences between the two. It would have needed to look at the code for MCC, it would have needed to look at the source code and the systems used for Medica Plus and genuinely ask whether these are the same thing or not. But I don't understand that that's the way the case is advanced. The second argument is that MCC isn't just coding, but it included non-coding elements. We say that's incorrect. The protection afforded under Article 2, I've taken your honour to, it's to computer programs and applications. Those are treated the same way as literary works. The extract of the academic text I took you to says that in this context, what's meant is the source code and the object code. So the actual words written in a computing language, which would fall to be treated as literary works. And in any event, so this is Article 3. In fact, we may as well look at it. If we scroll up, please, in the document that we've got scroll up. It's probably on page 5. So sorry, scroll the other way, please, to page 5. Yeah. Article 3, Your Honour, protection does not extend to mere ideas, procedures, methods of work, mathematical understandings, principle, abstract facts, and so on. So this idea that there are non-coding elements of this software is wrong as a matter of law. People can have ideas, people can speak to their clients and they can come up with, well, this is the reason we're going to develop this piece of software. But that is not what this law protects. Your work processes are not protectable intellectual property, nor are your ideas. And that also feeds into this idea of there being a transition from Medica Plus to Medica Cloud Care. I mean, effectively, the assertion is, well, they do the same thing. That's irrelevant. There are different iterations of word processor you can get through Microsoft Word, through a variety of other providers that do the same thing. It doesn't mean they're the same piece of IP. Similarly, I mean, if one looks at the development of mobile smartphones, one can't help but notice that the user interface of all of them is broadly the same. You've got little boxes with apps, you click on them and they open. The technology that lies behind it is different from what the user's experience of the product is. So the fact that they do the same thing, or that one does an updated version and a more technologically advanced version of the same thing, is neither here nor there. The question is, what is the protectable IP at the core of the technology? And the answer to that is the source code and the object code. So that argument doesn't go anywhere. There's no such thing as the non-coding elements that are protected by this law. The third point at paragraph 257 is they say that owning the IP is consistent with Health Insights Dubai's role as the front office, and then it includes the words "at least generally," and the words "at least generally" are doing quite a lot of heavy lifting there. And Your Honour will no doubt see the problem for the claimants, which resurfaces, we say again and again in these proceedings, which is if their case is Health Insights Dubai owns the IP outright, including economic rights in the IP, then why is it that since 2022 they've presided over a situation in which various different entities have licensed MCC for profit, and Health Insights Dubai hasn't been paid a single dirham, either by Al-Khalij or Health Insights Egypt or Health Insights Saudi? So when they rely on this suggestion that in general Health Insights Dubai is the front office, that is not the way the claimants are treating this business at all. And so it's strange to see them relying on it in order to assert ownership of the IP. And we say that's a pretty fundamental and irreconcilable contradiction that runs through all of the claimant's case, both in the claim and the counterclaim, which I'm going to come back to in a bit more detail next week.
Yes, Mr. Dockey, I see you've exceeded your hour and a half. Are you going to wind up soon?
Yeah, let me wind up this point and then we'll resume. The next point that's relied on is the claimants say there are substantial sums that were paid by Health Insights Dubai to Health Insights Egypt for software development. We say that there's no evidence establishing that Health Insights Dubai made payment to Health Insights Egypt for the development of medical cloud care. What's relied on, it seems, is solely historical payments that are reflected in the financial statements. I mean, the amounts total around $300,000 annually. So we're talking about a pretty modest amount of money, not what the claimants are describing as engaging up to 100 employees over a 2-year process. But you can see in the financial statements that those payments consistently go back. I mean, they're in 2013. So this is years before the claimants actually say MCC was developed. And there's no commensurate increase in expenditure that arises in 2016 and 2017. And the evidence Mr. Shehata gave is that this is integrations and training. So the idea, the evidence put forward by Mr. Shehata is that the Egyptian office were effectively human resource for implementations and for training. And that's what that relates to. The claimant's fourth point is the same as its first point, which is that M Plus is owned by Health Insights Dubai. The fifth point relies on the Interroco registration. Like I said, that takes place 6 years after MCC is developed. It isn't evidence at all of how MCC was developed or who acquired the IP as a result. You've got Mr. Shehata's evidence about why he felt in 2021 he had no choice but to do that given the situation the company was in. And in the claimant's own case, the Interroco registration is not evidence of ownership. The sixth point asserts that there's contemporaneous evidence of the fact that Health Insights Dubai owned MCC. Your Honour can look at the documents at paragraph 260 onwards. None of them are contemporaneous. The earliest one's from 2019. So really, there's nothing in there that's remotely instructive of the question of whether or not MCC was developed as a collective work. And the seventh point simply asserts that if you disagree with the claimants, the effect is going to be bizarre. That's not a relevant submission. The default position under the copyright law is that individual authors are the first owners of the IP. That position applies unless their work has been creatively directed by another and it's impossible to segregate the work such that it's a collective work. There is no carve-out in the law for a scenario in which the claimants think that there's been an economic or commercially undesirable result. If that is something that a company is concerned with, a company would put in place contractual mechanisms which address that problem. They would put in place terms in their employees' contracts which lead to the automatic transmission of any IP that they create. But there's no evidence or assertion that that's what happened here. We also make the point that one of the factual submissions made on this point is that, well, Ms. Heggie says that this is how she understood that her work was being done for the benefit of Health Insights. Ms. Heggie's evidence undermines the claimant's case on this point. What her evidence was during trial is that she thought that the company which paid her and other employees and the company that she worked for is the one that she would have thought owned the IP. But Ms. Heggie wasn't an employee of Health Insights Dubai, so I don't know how far her analysis can really take anyone. Now, just the final sentence I'd say is that having gone through actually, probably for your honour's benefit, the first time what the legislative provisions are. What it imposes is a substantial legal and evidential hurdle for the claimants in explaining what's really at the core of their claim, which is Health Insights Dubai acquired this valuable piece of intellectual property, which was then transferred away at an undervalue. To make good that case, they have to explain how the company conceptually and legally could have acquired that IP in the first place. And it would be extraordinary if, based on the evidence that the claimants have submitted, which does not include any technical details around how this software was developed and doesn't provide us with even the code that they say was developed and that was transferred away at an undervalue, it would be extraordinary based on those submissions and submissions that don't actually grapple with the requirements of the law. Your Honour could, as my learned friend suggests, safely conclude that there's evidence that MCC was a collective work. The legal analysis is unfounded. It doesn't work. And that's all I need to say for today. I'll come back to other points on this next week.
Well, let me take this. What I've understood your submission to be is the court cannot conclude that HI Dubai owned the rights, copyright rights to MCC. If that's so, then is the outcome that I don't make the declaration that is sought by the claimants, and I would go on then to consider whether I should set aside the transactions they ask be set aside on the grounds of conflict of interest. And on the face of it, I would, because their transactions entered into, or Mr. Shehata caused to be entered into, in which he is on both sides of the transaction. Indeed, one of the matters I had on my list to ask Mr. Montague-Smith, and didn't ask him today, is indeed going back to the points of claim. There's not even a claim there for relief in the form of a declaration for ownership of MCC. Indeed, one of the matters that I meant to ask and haven't yet, Mr. Montague-Smith, is that whether I would in any event make a declaration of ownership of MCC when it was not part of the original claim. But your answer to that is, in any event, on the facts and the law, I wouldn't make that declaration. But if that's so, again, and maybe you're going to deal with this next time, but I would then go on, in any event, wouldn't I, to consider whether I should set aside the transactions. And as I've said to you, on the face of it, I would, because Mr. Shehata's on both sides of the transaction. Is that the outcome that follows from what you've submitted so far?
Sorry, Your Honour, I wasn't sure if that was a question for me or if it was a question for Ms. Montague-Smith.
No, it's a question for you. Is that not the outcome? I point to you for your submissions today. It seems to me what you've said to me is that applying the law to the evidence, it's not possible to conclude that HI Dubai owned MCC. And the result of that would be that I would not make the declaration which is sought in the claimant's closing submissions, albeit is not in its prayer for relief in its points of, in its particulars of claim. But I would then go on to consider whether I should set aside the transactions which they ask be set aside. And putting to you on the face of it, I would, because Mr. Shehata's on both sides of the transaction. So
yeah, well, I take your
honour's.
Well, no, we say that that's not the outcome that should follow. So I'm going to address you on that when I pick up. next week, and really it's
okay.
It's a question of materiality of conflicts. That really the square point is that the transaction doesn't dispose of anything, and it certainly doesn't dispose of anything that Health Insights Dubai ever actually owned. And so we have some arguments around that, which I'll address you on. But obviously,
yes.
the findings of MCC ownership are in any event relevant to what the consequences are.
Well, that might
of any
be.
setting aside.
I mean, there's something you can think about and tell me about next week. It might be.
Yeah.
It might be relevant to the outcome of an account that I ordered. Indeed, I rather think things have got away from when I first raised the issue of the bifurcated trial. It was on the basis that the the first part of the trial would be determined whether an account should be ordered. And then the second part would be, if an account was ordered, then to take that account. And was my initial view that the question of the ownership of MCC should be determined on the taking of the account, because that goes to the amount of profit or gains or losses that might result in the taking of the account. But on the face of it, doesn't determine whether an account should be ordered, because, as I say, going back, Mr. Shehata's on both sides of the transaction, and on for the face of it, this no doubt something you can address me on next week. It seemed to me no answer to simply say, but HI Dubai didn't own MCC, because amongst other things, I recall in the transaction it warrants that HI does. HI Dubai does own it. There are all sorts of matters in that contract. It seems to me it's not enough just to say, well, if HI Dubai didn't own it, then there's no conflict. I've great difficulties, but that's a matter you can think of.
Yeah.
You can address me on next week.
Yes, that's correct, Your Honour.
And indeed, I was, as I overlooked putting to Mr. Montague-Smith, who can tell me next week as well, why I should be considering making a declaration of ownership when it was not in the particulars of claim, and it seems to me at the moment not necessary in order to determine whether an account should be taken. So perhaps those matters, yeah.
If I can just help on that, I mean, I think
All
that
right.
the point, I appreciate it's not pleaded as a claim for a declaration as to ownership, but I think what I was suggesting was that if, as we, I suspected, assumed, you were going to decide the question of ownership, and you may need to do that anyway, depending on where you come to on the counterclaim, because it seems to me to be implicit in my learned friend's counterclaim that HI Dubai had some entitlement to use this software, and if his case on Mr. Shehata's explanation that it all belonged to him and he licensed it through that is wrong, as we suggest it is, that then, you know, even if the effect of the consequence of my learned friend's submissions on the rest of it is that nobody owns the whole thing, it's this atomized piece of software owned by individuals who've got no idea that they own it. But anyway, HI Dubai couldn't possibly go around selling it. Now, it may be that you dispose of the counterclaim in various other ways, but my point was simply, if you do engage with that question, if you do reach a conclusion on that question, then from our perspective, it would make sense for the court to say, and by the way, we declare it. It doesn't add much to the findings, but I wouldn't press you on that at all if you decided that you don't need to make the decision. I can see that.
On one matter that you might both, this again a matter I overlooked putting to you in the first place, Mr. Montague-Smith, but a matter which has concerned me is that I might find it unnecessary to determine who owns MCC and unable to do so on the evidence. And if I came to those views and came to the view that I should set aside the transactions and order an account, would it then be open to both parties to lead further evidence on the taking of the account about ownership of MCC. Now, in putting all that, I think I've overlooked what Mr. Montague-Smith said about what effect it might have on the counterclaim, but I think it might be similar, that I might find on the counterclaim, or I could find on the counterclaim, that I'm unable to determine who owned, oh no, that's probably putting it the wrong way, unable to determine that H.I. Dubai owned the copyright, and may nevertheless be able to deal with the counterclaim. And again, the question that I seek assistance from both of you, if I come to those views and ordered an account, would it then be open to both parties to leave more evidence on the taking of the account about the ownership of MCC? So perhaps I can leave it with you for tonight, and you can both take that up next week.
Very good.
All right. Well, thank you. And as I say, we shall meet again next week.
Very good.
Thank you. Best
thank
wishes
you.
to your eldest daughter, if
Yes,
my
indeed.
memory serves.
It is. It's tomorrow. So thank you very much.
Well, thank you again.
Bye then.